You have extreme urgency involved in the matter.
Of the supplementary list?
Of today's list.
Today's list will not be approved. Sir, I'm sorry.
But unless this matter is taken up by day after tomorrow, my lord, the persons will be thrown out of position by the RR department, my lord, who has already supposed to give me the RR department certificate given to all others. We are the refugees, my lord. We are one way, my lord, thrown from Bangladesh.
Because every day I make it very clear that supplementary list matters will not be upgraded under any circumstance.
So should I give a notice to the other side? I come at 2 o'clock.
No, not at all. I'm sorry, not at all.
Well, otherwise, my lord, if it will become infructuous.
Any other matter?
It will become infructuous.
May I have your lordship's
Wait for
kind
your
leave to mention, my lord? Yesterday I sought your lordship's leave, and your lordship directed me to file, and
Yes,
matter
you
will
can give
appear.
the number.
Now, my
Yes.
lord, I tried to hand over the slip to your lordship's officer. You refused to accept
Please
it.
give the number. Please give the number.
May I?
Yes. Is it in the monthly list? Daily list matters. It's already in the list. It's already running in the list. It's already in the supplementary list. Give the number, please. Supplementary হলে করবেন না। দেখেন উনি বলছেন লিস্টে নেই।
May I be
Yes.
permitted mentioning? Well, two matters. There is a transit pass and private land. Your lordships already heard this matter. Only call for a report
Is it
for
a hearing matter or a motion matter?
no motion. Malad is appearing in the monthly list. Your lordships fix the matter somehow now appearing
Give
in
the
the
number.
list. Let
Give
it
the
be appear on Tuesday. I
Let me see. Give the
notice.
number.
Yes.
Appearing the monthly list, my lord, for obligation.
Is it urgency?
My lord, the private are making unauthorized construction over the government land in front of the petitioner and lodge a complaint to the government authority.
Give the number, please.
My lord,
My lord, may I have your
It is.
Item number 947 of the monthly list. I have been called for a hearing on 3rd of May. I have been said you remove your everything by 15th of May. It's a market. It's not my own property. It's a market of 27 years old. And by the patronage of Didian District Magistrate, this was set up, my lord, just beside the newly constructed administrative building. Now, 32 families are going to suffer. We have been paying all taxes, all fees to authorities, having trade license and others. It should be
Give the number. Give the number.
my lord, may I be permitted? My lord, this is another e-rickshaw matter. I am praying for upgradation. This is appearing in the monthly list as item number 986.
Of the monthly list?
Yes.
Give the number.
My lord, may I be permitted to mention item number 152 of today's list? But my lord, I understand the matter is not upgrading,
I
but
have
the
just-
only urgency is, my lord, on 17th I have been given, my lord, notice that will be evicted. I'm carrying the writ petition, my lord, on 17th of this month. But the notice was served upon us on 29th of April, indicating that I'll be evicted by the Southeastern Railway on 17th of May. My lord, we are more than on 120 years in that premises.
Let us see, come back
Well,
next week. Let us see.
My lord, kindly considers that, my lord, on any day
Next
before 17th, my lord.
Difficult. Let
My lord, may I mention?
May I come back on Monday, my lord? May I come back on Monday?
Supplementary list matters, upgrading them is.
My lord, it is extreme urgency, but I'm carrying the notice. Man, kindly looks into it. It is, my lord.
সোমবার থেকে mentioning বন্ধ করে দিন। I'll take up matters according to the list. No mentioning will be allowed. from
Our
Monday.
matter was not
I'll
in the
take-
monthly list.
So that I can take up the matters of the supplementary.
Our matter was not in the monthly list. We filed it automatically. It has come in the supplementary. So by chance to mention the matter as is being given to the monthly list persons, but that should be also be
I
applicable to
will
us.
stop accepting mentioning of matters from Monday.
No, urgent
so that
matters,
I
my
can
lord,
deal
we
with
can
the
mention, my
supplementary
lord, of course, my lord. Should we
Let
not-
us see. Let us see.
It will fall upon the bar's interest or person's interest. We have not
Both
committed it.
cannot run simultaneously. You mentioned 50 matters a day. They are included in the supplementary list.
No, I have
Step
not mentioned.
one. The
This is,
step two is upgradation of the supplementary list. It cannot be. allowed.
well, it has not been mentioned at all. It has not been made. Automatically, it
Please
has
come
come in
back
the
next week,
supplementary
let me
list.
see. Please come back next
Well, if
week.
it is
let me see.
automatically coming in the supplementary list, upgrading the matters, my lord. It
Please
is,
come back
I
next
have,
week. Let me see. Yes.
I shall come on Monday then. Chalo.
Yes, how so many contempt applications cannot be taken up together. Give 5 at a time.
My lord, I have given the number and on
Give 5 at a time, sir. I will not accept 48 petitions, maybe, but they are not connected. They have been dealt with by separate orders.
my lord,
They have been dealt with by separate orders.
my lord,
The judgment may be the same, but they are separate orders.
my lord,
So please come back 5 at a time. I will not consider this.
my lord,
My-
but the.
My lord, may I mention an inclusion?
Kind attention, my lord. My lord, the issue is that the contemner is same, the intervener is same.
Maybe,
My lord, and
maybe,
all are canvassed in a one contempt.
maybe, but come back 5 at a time, sir. Cannot be taken like this.
Allowed, my lord, as per your.
Give a separate list of 5.
My lord, then I am handing over the,
Give a separate list of 5.
my lord, I am giving it.
My lord, may I mention for inclusion, contempt matter?
Contempt matter, give the number.
My lord, may I be permitted to mention the matter, my lord? My lord, I am seeking a leave of the lordships, my lord, to file this matter on urgent basis and to take up this matter on urgent basis. Because, my lord, the special land acquisition officer who wrote on is acquiring the plot of land of the petitioners illegally and forcefully and aggressive manner without paying, my lord, fair compensations in according to the market value. My lord,
Can come back. There can be no urgency for filing.
my
File and
lord,
come
my lord, my lord, my lord, if
File,
your
if
lordship-
the number, I'll consider.
if your
It is
lordship
not
take up-
necessary for on this ground.
Well, may I mention inclusion in the list matter? Matter was already disposed of, thus recalling the order dated 23rd December 2022.
Yes.
Is a matter was in first award copy has not supplied by petitioner. Just recalling the order, my lord.
Recalling the order.
Yes,
Have you put the other side of notice?
yes, serve the notice. A petitioner as well as other respondent.
Give the
I am
number,
for state respondent.
The number, let me see.
Permitted to mention for operation from the combined list to supplementary.
What is your urgency?
Urgency law, lease is expiring on June.
Yes,
Lease is expiring on June 2023.
come back after vacation.
Lord.
Come back immediately after vacation. You have some time with you.
May I have my lord's kind leave me lord, to mention item number 942 of the combined monthly list. My lord, the urgency is my lord, the land acquisition proceeding has lapsed my lord, by expiry of my lord, efflux of time. My lord, despite my lord, the acquisition proceeding having been lapsed, my lord, we are not being allowed my lord, to utilize my lord, the land my lord, on a plea that my lord, this may be still my lord, pending acquisition.
Oh,
My lord, makes no sense, but my lord, that is the language of the
report is necessary
communication.
from the state respondents.
Yes.
Give the number, please. Let me see.
942. My lord, may I hand over? My lord, I will my lord, hand over a slip.
My lord, if I may have my
Yes.
lord's kind leave to mention, my lord, a new motion matter, my lord, this was lastly appearing before my lord Justice Shane Gupta. We have since, my lord, gotten it released. My lord, the urgency is, my lord, I am in the business of, my lord, rice manufacturing. My lord, I have twofold prayers in the writ petition. The land adjoining, my lords, was settled in my favor. The formalization bit was remaining, for which, my lord, I've come up before your lordship. And the second portion is, my lord, over the very same land, my lord, the state government, my lord, has authorized the commissioning of a, my lord, a plastic waste management system, my lord. Just before my facility wherein, my lord, my lord, I'm manufacturing
same land?
on the same land, my lord.
Give the number. Give the
My
number.
lord, I'm so very grateful, my lord.
So may I pray for a contempt application?
My lord, may I permit to mention? Sorry, item number,
Please, take your breath. Please wait for 2 minutes. Take your breath and then. mention.
item number 9, my lord, for short possible, my junior is coming on the way. Short possible. Item number 9.
Item number 9 has not been called. Let me call the list, sir.
Mentioning.
I'm mentioning what is, for short possible, I'm mentioning.
I do not understand. Mention
Mentioning, madam.
Passover of mentioning.
No.
No.
Mentioning.
No, he says item number 9.
For short possible.
call hoenge.
Oh, acha.
Please wait. I'll
I'll
call.
wait
I'll
for
call.
that.
Please
You
wait.
do.
I'll call. No, please take some time. Yes, call the raise list, please.
Item 1.
My lord, appear for the writ petitioner, my lord. My lord, this is appearing for extension of interim order. My
Have you
lord.
served? Who is appearing?
My lord, we will,
Respondents?
my lord,
It was standing in the list.
it was running in the list, my lord. My lord, what has happened? Just a second. My lord,
Running in the list, but it will be taken up today. Have you informed the respondents?
my lord, no, my lord,
Then how can it be taken
my
up?
lord, we are intimating, my lord, kindly allows us that liberty. My lord, interim order is of 10th. My lord, I'll just indicate, my lord, 11th of April 2023. My lord will kindly,
The Mahaka was appearing. Please inform him and come back next week.
my lord, kindly gives us that extends the interim order. It was
In
till the
absence
last,
of the other side, no.
my
You
lord.
should have served earlier when you're in such urgency.
My lord, the matter was still 10. My lord, I'm kindly. My lord, I will intimate to personal, my lord, and my lord,
It
kindly.
was extended till 11th April.
Yes, madam.
Today is 12.
Madam, 10th of May.
10th of May.
Yes, madam. My lord, 11th of April also.
All right. Yes.
My lord, you got the list on 10th of May. We had
Yes.
mentioned, my lord, kindly answer that. I will personally.
This is appearing on mentioning, isn't it? You mentioned it yesterday.
Because since the order was expired.
Yes. So you should have put the other side of notice immediately, which you have not done. So please do that and come back, not today. Come back on Monday. Have you filed an application for extension?
My lord, my lord, I will bring the other side.
After the order is passed, you'll bring the other side. What are you saying, sir?
My lord, I will email.
No. You missed your chance. Come back on Monday.
Item 2.
If it's so urgent, why don't you inform the other side? Thank you.
Only this I am for the petition and lordship, the order impugned hearing lordship, the appealable under rule 51 concession rules. So I want to
You want to
this
withdraw?
matter, liberty to prefer appeal to the appellate authority.
Absolutely.
Lordship. The affidavit service
Affidavit of service.
order impugned page 190.
It is submitted on behalf of the petitioner that the
Page 190 lordship
190.
190. 6 December 2020.
That the order impugned in the writ petition passed by the additional district magistrate and district land and land reforms officer Paschim Bardhaman on 29th November 2022.
Lordship
is-
6 December. Lordship kindly come. 6 December. This is the first order, then the 2nd December, 6 December.
All right, I'm sorry.
Lordship.
6
Yes.
December 2022 is amenable to appeal under Rule 51 of the West Bengal Minor Minerals Concession Rules
2016.
The writ petitioner seeks to withdraw the writ petition and approach the appropriate forum for redressal of his grievance. Paragraph in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, the concerned appellate forum is requested to deal with the in the event the petitioner refers the appeal within 7 days,
15 days.
within 15 days from date, comma, the appellate forum is requested to deal with the appeal on merits without dismissing the same on the maintainability issue. Dismissing the same on the maintainability issue.
This is also the same. 3.
Please also say
Same. The order date also same.
date of the order,
Same.
3 same order.
Same order. Grateful. Affidavit service will kept to this.
Court,
Lord, I beg to appear for the writ petition. My lord, this is that matter where the state has filed a recalling application in the form of an appeal.
where is the state?
My lord,
Item number 5. Item number 45, my lord, there is also an EB application. My lord.
Yes, so please,
My lord, 41/22. This EB application was dismissed or withdrawn, my lord, because there is some mistake and lordship liberty was given to file fresh review application. And that new review application which is filed, my lord, that is review 30 of 2023. That once it was appeared, but thereafter it is not appeared. My lord, kindly that is the my lord to appear the review application 30 of 2023.
review is not, yes, review is.
Well, it is
was-
appearing, ma'am.
It is appearing all throughout.
My
Why
lord,
do you-
yes.
22, it was dismissed because some mistake was there. And
41 by
liberty
22 na,
to file case.
Yes, what is the fresh application number?
30 of 2020.
লিস্ট অ্যাপিল করছেন আগেরটা ডিসমিস হয়েছে
Date is my lord, review application appear, my lord.
My lord, it is,
41 of
my lord,
22 ডিসমিস হয়েছে
হয়তো তোমাদের সার্ভিস করে যেত
সবই আছে, অ্যাপিয়ার করছে, প্রতিদিনই অ্যাপিয়ার করছে, 30 অ্যাপিয়ার করছে। আমি অপোজিশন পর্যন্ত ফাইল করেছি।
আরে লিস্টে দেখো না 30 টা কোথায় অ্যাপিয়ার করছে, এটা তো 41 তুমি দেখো আগেরটা অ্যাপিয়ার করছে।
We'll let it appear. It's not appearing in the list.
But on the last occasion, we have filed our opposition to the review 30 of. But my lord, the same problem is there, my lord.
Prima facie it appears so.
Yes.
Let me just see.
Motion will be taken up first, লেখা আছে today. Motions will be taken up at 10:30. লেখা আছে।
You are referring to page 6 of the review application? This is not an appeal, sir. The honorable single judge ought to have considered the fact. What is this? Yes?
আছে ma'am,
It is with me.
আছে, just highlight that.
Please come. Maybe, but both of you are there. Please come to page 6 of the application. Say that. Page 6 is in the form of an appeal. You're asking for a review and blaming the single judge. Is that in accordance with law?
And one fold, that is one fold. And the second is that still they have not filed a section 5 application. Order is of, my lord,
কালকে রাত্রিবেলা 6টার সময়।
Let it be dismissed outrightly.
ওইটা আমি অনেক ব্রিফ গাচ্ছি।
Very well, not today. Let them come.
এই তো ব্রিফ রেখে গেছে আমার।
এটা দেবেন
আর
to
brief?
Mr.
এইটা আমি অনেক ব্রিফ গাচ্ছি।
এইটা না। ওটা dismissed হয়ে গেছে। Withdrawn. Next one.
yes,
My lord, item number 6, my lord. I am fully contender, my lord. The petitioner advocate, my lord, requested me to take not today, my lord. Although, my lord, we have already filed appeal, my lord, MAT 811 of 2020.
Who is appearing for the petitioner?
Well, people are good. Asubudin is good.
Huh?
6, 7,
666.
My lord, I'm for the petition.
In this matter, my lord, we have already filed, my lord, MAT 811 of 2020.
Let it be not today. Let the petitioner come.
My lord, I'm for the petition.
You are for the petition? Start.
আরেকদিন ছিল চলে গেছে অ্যাপিল ফাইল হয়েছে
He's asking for an accommodation. on
yes
your-
my lord appeal has been preferred
Appeal has been preferred.
appeal has been preferred
So out of list for the time being.
my lord kindly my lord fixes a date my lord anytime my lord after the vacation my lord a longer date my long date my lord
In view of the submission made on behalf of both the parties that the order under contempt has been carried in appeal by the alleged contemner, comma, let the matter go out of list. Liberty.
my lord I have not been served with any copy of the appeal or the number at all my lord read. Sir, appeal has copy my lord.
The order under contempt. বলেছি। Hmm.
Well, in this order, I appear for the petitioner, my lord. My lord, case of the petitioner is, my lord,
কত টাকা এটা?
the petitioner. The state is.
This is appearing.
এটা কি কন্টেন্ট?
Who is appearing for the state? Mr. Bandopatra is appearing.
To be mentioned.
My lord,
You wanted to take instructions.
my lord.
ওই নোটটার মানুষ
After.
Dismiss হয়ে গেছে।
On prayer of the state respondents, the matter is adjourned. Let the matter appear under the same heading on 14th June.
Your Lordship, I am appearing for the petitioner.
But I am for the private respondent. Your
Lordship.
Who is appearing for the state?
Advocate Wasim Rizvi, Your Lordship.
Where is he?
My lord, your lordship was, my lord, last person directed me.
The West Bengal Premises Act so that the petitioner could be added as a party.
First,
This court has determination, sir.
my lord, and my lord, your lordship was directed me to put the document with regard to the appeal.
The appeal number, Your Lordship, so that I can be added as a party in that appeal. The eviction order that was passed by the SDM. The private respondent is an encroacher. The SDM passed an order for removal. After that, I had preferred this particular writ petition whereby the private respondent came and said that they have preferred an appeal. But I was not made a party over there. On the last date of hearing, Your Lordship had directed them to provide me with the appeal number.
What is your prayer in the writ petition?
So that the order of the SDM is executed.
For implementation of
Execute, Lordship. As per the state record, Your Lordship, the appeal was filed on the 9th of January. We are in the month of May, Your Lordship. The appeal has not been executed. I have not been made a party. Nothing has been done, Your Lordship.
Have you served?
No, Your Lordship. No, Your Lordship. I am the applicant, Your Lordship.
Please give him the number. Please give him the number.
This is the receipt with regard to my admission of
How- Your Lordship, how can I be added as a party unless there is a number to that appeal?
This is the copy of the memo of that.
Take the names of the parties and find out, because he has not received the number, he says.
Your Lordship, let the state be directed because if the more than 5 months have passed and the DM has not even started the hearing, Your Lordship.
May I just, my lord,
So the writ petition is not necessary.
Your Lordship, yes, Your Lordship, kindly direct the DM to proceed with the appeal and dispose it off within a period of 1 month. Your Lordship. Your Lordship, I want to be added as a party,
First, file an application for addition
but
of
for that I
party.
need
But
the
that
appeal
was-
number. For that I need an appeal number, Your Lordship.
That was the last option.
How can I add myself as a party unless I have the appeal number, Your Lordship?
Find out from the office of the DM.
Your Lordship, the state can provide me with that particular information, Your Lordship.
Please appear for the state. I do not find anyone for the state.
Last option is appearing on the state and your lordship, please to my lord,
Today I do not, maybe that's the reason why the state is not appearing. I do not find anyone for the
Your
state.
Lordship, kindly fix, not today, Your Lordship, can you fix it tomorrow, Your Lordship?
How will it help you?
Your Lordship, I'll intimate the state and this.
To keep this pending.
yes, my lord.
Your Lordship, then kindly grant me the liberty to make an application before the DM, and
That was lordship observation last option.
on the last occasion, Your Lordship had directed the private respondent to provide me with the appeal number, Your Lordship. That was not the observation. The observation was to the private respondent will provide the information regarding the appeal. Your Lordship, kindly peruse the last order, Your Lordship. Kindly peruse Your Lordship's order.
Your lordship directed me to produce the copy of the receipt of the appeal.
The appeal is before the DM.
Yes, Your Lordship.
I'll just request the DM to dispose of the appeal as expeditious.
After adding myself as a party, Your Lordship. I should be added as a party, otherwise how will I make my case? It will be X party.
Cannot be given in a writ.
So today there is no application at all. There is no filing application. From the bar he is coming there, I will file an application.
Your Lordship, if I am not added as a party, it will proceed X party.
But they might, you also can
Find it before the DM office. You know the names of the parties.
Lordship.
Make a search and find out.
Lordship.
How do you get a number when it's not provided to you, sir?
Lordship,
There is
this-
a procedure.
I understand, Lordship. It's the duty of the state to provide with me with the number, Your Lordship.
It's not the duty of the state because you're not party to the appeal at all. So if you're interested, you have to find out and apply.
That was the observation last occasion.
Let the
One
petition
indulgence,
be
Your Lordship.
disposed of.
One indulgence, Your Lordship, let the DM be directed with a time period within which he'll dispose of the appeal.
He has not been filing any application, my lord. Let the application be added.
I will
The
make the
application will be
application
taken
after
up for
the
hearing.
That it has to be disposed of. Get yourself added. None appears for the state respondents paragraph. Let this remain on record.
Well, may I get a photocopy of this one and keep it, my lord? Because this is the original, my lord. This is, I have to hand it over, my lord, the original copy of this one.
Submitted on behalf of the
Your
private
Lordship, let him provide
respondent
me a copy with the appeal, Your Lordship.
that the private, that
I
the
use not a party, my lord, I will keep you.
order, where is the order impugned?
My lord, the order include, my lord, that is at page.
Page 35 and 36.
Well, initially the proceeding was initiated under
That the order passed by the subdivisional magistrate Baruipur, South 24 Parganas on 13 December 2022 has been carried in appeal by the private respondent, and the appeal is pending before the district magistrate, Paschim Medinipur.
South 24 Parganas. South 24 Parganas.
District magistrate? Alipur. District magistrate, South 24 Parganas. Since the writ petition,
And within time, my lord, this appeal is.
no direction can be given because he is not a party and
Yes,
it is
yes.
his writ petition.
Yes, yes.
Lordship, may I be provided with a copy of the appeal?
Since the, give him the copy.
No, he is not a party, my lord.
Lordship.
If your lordship direct me, I shall come.
I will not give a written direction.
But-
Will it be very difficult for you to give him a
Because
copy?
I am not made him a party in the proceeding, my lord. If your lordship not direct me, I
The
shall
original
come.
complaint was made by me, Your Lordship. How can I not be a party, Your Lordship? If I am provided with an appeal, that will be for the benefit.
By
for the-
now you have understood that the
Yes, yes.
others will not cooperate with you. So please take necessary recourse to law.
Lordship.
Yes? It can only be a request. I cannot give a direction, isn't it? Since the writ petition prays for implementation of the said order, comma, no fruitful purpose shall be served by keeping the writ petition pending. Paragraph in view of the above, the writ petition being WP such and such is disposed of. Urgency deferred, that's it.
Deeply grateful. May I, my lord, give a photocopy of this, photocopy of the order?
Please do that.
My lord. And
And
it is
it
not-
will be photocopy. Okay, the thing photocopy.
আমি একটা ফটোকপি করে দিন
Dispose.
ডিপলি
Next.
দিয়ে দাও, রেখে দেবো।
Nine.
and I will leave on my junior is actually. Please allow.
Respondent number 4.
My lord, the
Respondent
response,
appearing in person.
yes, my lord, respondent number 4 by yesterday, he tried to make the online application for V-conferencing, but yesterday it failed. And today he missed it. If it can be linked, he's waiting there. He has sent partition. Oh, he has sent.
Mr. Potokar, you wanted to take instruction?
Yes, madam, we have received instruction. madam.
Thanks.
No. Paragraph 7, my lord, has stated.
Let us see if he is able to appear.
My lord, then a small passover, he's anxiously waiting to enter. But since the link has been sent, yes, he has entered.
So what is the matter about?
Yes, my lord. This case is regarding transfer of a leasehold property in Salt Lake. Accordingly, the respondent number 4 has made an application for transfer of a percentage, of a certain percentage from his share to the third party. And this has been allowed by the government notification since 2012. The only condition is that you have to pay a transfer fee of rupees 5 lakhs per kata. Accordingly, they made an application, and in particular, the application they have also annexed with the reply. There it is specifically mentioned that it has a shop. And my lord, right at the inception of the plot, this plot was marked for shop allowable. And a notice has been given to the respondent prior to purchase that you have to pay extra 10% for shop allowable, which he agreed. So the price of the plot and additional 10% makes the total price. That price is mentioned in the transfer lease deed. But by mistake, in the transfer lease deed, they did not mention the word shop allowable. Now the point is, in terms of the law of contract, this has already been assured in the allotment letter. followed by payment, followed by handing over possession, followed by building plan, showing a shop, which shop has been, the sanction, plan has been sanctioned, building has been constructed, the completion certificate has been provided with respect to the shop and the entire premises, and thereafter he makes an application to the land manager that you allow me to transfer this certain percentage. Now everything, the land manager has also confirmed in his instruction that that it has been verified by the Bidhannagar Commissioner, the police department, by the surveyor of the land urban development, as well as by the Bidhannagar Municipal Corporation. Everyone has said yes. Accordingly, the interview took place, and in the interview, they passed the order that your application dated March 2022 is allowed. You make the payment of this amount, 10 lakh some amount. So accordingly, the amount has been paid. Thereafter, the order has been passed and has been directed to submit the draft copy so that the vetting can be done. In the draft copy, we have mentioned it is shop allowable. The vetting had been approved. Thereafter, they call us for the execution. On the date of execution, the transferor, transferee, along with the respective witnesses were present. The land manager's office produced the deed to them, and all of them has executed and signed the documents. When the turn of the land manager came to sign, for reasons best known to him, he said, I will not sign. Then we asked him, what is the reason? Then he said that I will not allow an odd fraction. I will allow only 50%. Then we said, sir, if it is 1/3, then what will be the fraction? 33.33. Fraction doesn't make any sense. And your superior authority has approved it. Thereafter, he says that I will not allow the shop allowable. Then again, I reminded him that in terms of your predecessor's commitment, this is a shop allowable plot. And accordingly, the additional price has been paid. Now, if I do not write shop allowable, then the registry department will say that it is not a residential building. You are showing it a residential building. You are depriving the government with the proper stamp duty. I cannot do that. So on this basis, my lord was pleased to direct the state respondent to give instructions regarding this matter. In the instructions, they have confirmed whatever we have said, but they have never mentioned what is the dispute according to the line manager. If you go through the instructions, your honor. Can I go copy? Yeah. Yeah. Yes. Paragraph 9.
But before that, paragraph 7, it hasn't stated, my lord. Why, my lord?
Yes, he's saying it is not matching with the model copy. What is the model copy? Where it is not matching? That is the cause of action of this today's case.
What is the model copy?
My lord, there is a model copy of this department that has been supplied to the petitioner, and they have prepared the deed on the basis of that model copy, but somehow that is not matching, my lord.
Matching
This
is
is my instruction. It is not matching. That is why the land manager has not, my lord.
Kindly look at page number
Very
163.
vague. Show me where it is not matching and how it is not matching.
All these things
Yes.
are not mentioned in the, my lord, instruction, not specifically
Yes.
mentioned. But this is not matching with the, my lord, draft copy. That is why, my lord, they have not.
Your honor, kindly have a look at page number 165 of the model copy.
And my lord, kindly see, my lord, page, my lord, 34. That is the, my lord, letter of allotment of the writ petition. Page 34 of the writ petition, my lord.
Yes.
34, my lord. You have to kindly see page, my lord, 36 of that allotment, my lord.
Yes.
Clause F. Right. Here it has specifically mentioned the plot of land will be used exclusively for residential purpose and for no other purpose. It is specifically mentioned in the allotment letter.
Very correct, your honor.
There are subsequent developments for which he had to pay additional charges
It is true, my lord.
for using it. So
Yes, yes.
if you say it is true, then what is the difficulty?
But from instructions, it appears that the deed is not matching with our original allotment.
It's not matching, and where is it not matching? Please show me.
Yes, my lord. That is not specifically mentioned in the
I am
instruction.
explaining it, your honor, my lord. Kindly look at page 165. Just one instance I will show. The schedule B above referred to sale leasehold property, page 165.
Yes.
It says all that leasehold right title interest of undivided blank share of plot number blank in block in sector move in northern Salt Lake City extension area in the district of 24 police station, Bidhannagar, northeast south, registration office, additional district sub-register, Bidhannagar, Salt Lake City, Kolkata, along with undivided blank share of the construction thereon for the unexpired balance period of the term mentioned herein before and decided in the deed of assignment of lease dated at. If we have a careful look at this clause, nowhere the area of the house is mentioned. The register says that if you do not mention the area of the built up area, I cannot make assessment. I will not allow this. Now there is a dispute between the ADSR and the land manager, and we are running like a shuttlecock. Without the area that we have mentioned in
Have you
details.
mentioned the area in your deed?
Yes. So he says you cannot mention. You have to follow this schedule. No area will be mentioned.
The submission, whether that has been they are submitting that.
Then please point out your discrepancy that you have stated here.
That is, yes,
So this is very vague.
or you also may direct the land manager to let them submit a complete representation stating their grievances.
That is not necessary. The grievances are on record.
What is the specific
Since all the other authorities, the superior authorities have agreed to this, they have, the land manager has no business.
I shall take my further instruction specifying what is the
I would like to know what discrepancy is the land
yes,
manager pointing out.
specific.
And I would like to have that on affidavit, on record, so that I can take necessary steps. Let him come back with a.
Yes, I have no hurry, my lord. My only submission is
Come back with a report in the form of affidavit.
they should give reply to the grounds of appeal. Specifically to the grounds of appeal. It is specifically mentioned over there. They are delaying the procedure because my deadline is 30th September.
Tells it explicitly. I mean,
Yes, yes,
it's
no,
very
not,
vague.
yes, yes. This instruction is not specific, it's true.
Reply to the grounds of appeal may be given.
Till draft deed of assignment, there is no dispute.
Yes,
Then at the time of execution, you find that the copies are not matching.
not matching.
What do you mean by not
Why
matching?
not
Please
matching?
find
That
out.
is not
Please
stated.
come back with specific
yes.
instructions on this.
Probably I could not satisfy the land manager by other means.
Let us not go into that. Let him come back. That's why I want to put it on affidavit. The written instructions submitted on behalf of the state respondents is taken on record. Paragraph, it is submitted on behalf of the. Yes, Mr. Mitra, do you want to add anything to this?
Can you hear me, ma'am?
Mr. Mitra,
Can you hear me now?
are you able to hear me? Am I audible?
I can hear you, madam, but can you
Yes,
hear
Mr.
me?
Mitra,
There is nothing to add, madam. Everything is what.
Yes,
you are
ma'am.
not audible, Mr. Mitra.
Hello, it
You are not audible.
it is muted from your end, madam. It is to be.
Yes,
Mute for a
yes, please continue.
mute for a
You are not audible, I'm sorry. He's not audible, he's saying something.
It is unmuted, to be unmuted. Hello, hello.
Yes, yes,
Yes, can you hear me now, madam? Hello, hello, hello.
you are not audible.
Hello, hello, hello. Hello.
You're not audible, Mr. Mitra. Please unmute yourself. Please unmute, Mr. Mitra.
I have unmuted it.
Yes, yes, now it's unmuted. Yes, yes, please make your submissions.
Can
Do
you
you
hear
want
me?
to add anything to this?
No, nothing to
The
add.
state needs to come back with with a report in the form of an affidavit.
Yeah, I have nothing to add, madam.
Very well, very well.
Oh, thank you.
It is contended on behalf of the petitioner that the plot in question was allotted to the fourth respondent on lease for a period of 999 years. Subject to prevailing terms and conditions which inter alia included payment of a premium or salami charged at the average rate of rupees 8,000 per quota, and the private respondent paid extra charges for shop allowable plot to the tune of 10% of the total cost of the plot. Stop. The private respondent intends to transfer a share of the property in favor of the petitioner being undivided 50.512% of the share and complied with all necessary formalities for the same. Though the proposal of the private respondent was accepted by the concerned authority, the land manager, being the third respondent herein, refused to sign the deed of assignment.
Deed of assignment.
Sign the deed of assignment for no valid reasons whatsoever. Paragraph. In the written instructions submitted on behalf of the state respondents, it is stated that at the time of execution of the document, it was found that the document was not matching with the model copy of the department for which it could not be executed. Stop. There is no whisper in the said instructions as to the discrepancy between the document and the model copy as alleged. Paragraph. Learned Counsel for the state respondents seeks to submit a report in the form of affidavit clarifying this aspect. Paragraph. Let the matter appear under the same heading. Please serve an advance
Yes,
copy, Mr.
yes.
Bhattacharya. On 19 June.
On 19 June.
19.
Your Honor, I have received only a single copy. The annexes has not been given to me.
He'll come back with an affidavit.
Today's annexes.
He'll come back with an affidavit.
No, today's report, I have received only single page. The annexes has not been given in this.
This is instruction, not report, madam. That is why.
Sorry.
Instruction,
Okay,
let him
okay.
come back with a comprehensive report.
Okay, okay. Should I need to give any reply in the meantime? To save time?
You want to?
Yes, I want to give a reply.
Report in the form of affidavit be submitted on the adjourned date upon service of advance copy to the petitioner. Paragraph. On prayer of the petitioner, liberty is granted to use an exception to the report, if required.
Much obliged.
Item 10.
Well, in this matter,
the acquisition started by the collector and as well as the competent authority, because this is national highway. Well, at last occasion,
The national highways?
well, national, now it is before the DM, because my grievance is against the
Have you
DM.
served the national highway?
Serve করেছি দেখে নাও। Serve
The affidavit?
দিয়ে দাও। Serve.
The one is there for the national highway?
Yes, it has been served. Well, now the only question is this: the land belongs to my father. Well, we have 3 brothers, 2 sisters. Inadvertently, my lord, 4 names has been recorded in the record of right. My name was left out. Well, I being the owner, I should be given the award, well, that compensation. Well, notices were served upon my 3 brothers and 1 sisters. Because since my name was not recorded, I have not been given the notice.
Rightly so.
That's true. Therefore, my lord, I made an application before the authority. My lord, that is demand notice, page 11.
Yes.
My lord, I have requested them to ascertain the ownership and to disburse the compensation.
Where is your representation? Demand
Represent,
notice cannot be considered.
this is my letter of advocate.
Why do you involve advocate first? There
Well,
should be
this is
representation.
demand letter.
You cannot demand before a request is made.
That cannot be. That-
So will you file a comprehensive representation before the authority?
Lordship.
Yes, stating the entire facts?
So far as the ownership is concerned, the authority has no authority to decide, my lord. Ownership is not the appropriate, civil court is the authority, my lord.
If it
And
is
they-
disputed, the civil court will intervene.
They are claiming that their name has not been recorded, that
Let
is.
you file a representation, let the authority find out
Yes.
upon hearing the other co-sharers. If there is a dispute, it will be referred to the civil court.
Civil court, yes.
Yes.
Yes. Affidavit of service. None appears for the National Highways Authority of India. Expired service. It is contended on behalf of the petitioner that the plot in question, plots in question, originally belonged to the father of the petitioner, and upon his demise, the petitioner, along with her sister and 2 brothers,
3 brothers. Total 5. 3 brothers, 2 sisters.
sister and 3 brothers, have inherited the same jointly. Stop. Since the petitioners, the plots have been acquired subsequently. Stop. Since the name of the petitioner was not recorded in the record of rights inadvertently, no compensation has been paid to the petitioner in lieu of acquisition of the land, and notice of compensation has been issued upon the other co-sharers only. Stop. The petitioner seeks to submit a comprehensive representation in this regard before the concerned authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that who is the authority?
Stigmatized.
This one, who is they have not added the special land acquisition officer, is the appropriate authority.
No. Another National Highway Act, competent authority is the authority. That is DM. Your Lordship, kindly peruse this notice.
Let it go to the DM.
Yes, notice ta dekha.
The second
Issued
respondent
by
be
the
directed to
district magistrate
consider the
competent authority.
representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of,
Yes, ma'am.
directing the second respondent to consider and dispose of the representative, disposed of with liberty to the petitioner, with liberty to the petitioner to submit a comprehensive representation before the second respondent within 7 days.
7 days.
Within 7 days from date. Stop. The second respondent is directed to consider and dispose of the representation within 2 months from the date of
No,
communication.
my lord,
from
the
date of
process
receipt
is
thereof.
ongoing. Award has not been, my lord, made over to the claimant. Process is ongoing. Let it be within 1 month.
No, my lord, 2 months. Process on it, there is a land acquisition proceedings, my lord. And their representation.
Ascertainment of the ownership.
6 weeks.
6 weeks.
Within 6 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, pending disposal of the representation, the concerned authority, being the second respondent herein, is restrained from disbursing any compensation in favor of any person in respect of
Plot numbers.
plot numbers 272 and 749
Yes.
under Moja Podua, PODUA, police station Chandrakona, measuring about 1.28. You put a
1.28 acres.
1.28 acres.
Another is 0.8
And
acres.
0.08 acres
Yes.
respectively. Disposed of it.
Deeply.
Pending disposal of the representation. Pending disposal of the representation.
Item 15.
And for the petitioner. Praying for a short passover, I am led by
Not
Mr.
possible, sir. I'm sorry.
Mr. Basu is appearing in this.
Short passover is not possible. I'll give you a date. Come back after vacation. On the earlier date also, that's that, gentlemen.
Lordship. Then Lordship may kindly allow me.
Yes, you'll make your submission?
Lordship.
Yes.
This is the second round of writ petition, Lordship. On the earlier occasion, your Lordships directed the respondent authority to consider my prayer in respect to get the lease of the water body, which the water body in question is 50%, more or less 50%. I am the owner by the inheritance,
Yes.
and the other portion is vested in the name of the government. So my father, on the earlier occasions, when he was alive, got the lease from the respondent authority in respect of the vested part. Thereafter, after the death of my father, I made application for getting the lease, and thereafter they didn't consider my prayer. But as the water body is a whole in question, I am already started pisciculture over the said water body. But on that ground, I made representation for non-consideration of my representation. And your Lordships directed the respondent authority to consider my representation without observing that the father of the petitioner is already getting got the lease over the vested part. Thereafter, I made communicate the said solemn order passed by your Lordship, and then the impugn order passed by the respondent authority concerned on 13th January 2023, which is annexed in page 54, running page 54, stating that they set aside my representation by stating only on the ground that no formation of the cooperative or any group for the pisciculture, I am not entitled to get the lease.
The order is at page?
Starting from page 54, the order sheet is page 55, Lordship.
Your portion is more than 50%.
More or less 50%, Lordship.
Yes, they have rejected.
It's not, it is, can you see my page 55, my lord?
Yes.
273, my lord. It is specifically stated if the private owner is more than 50% or 50%, then my lord, the lease will be allotted in favor of the private party, my lord. Here, my lord, the petition is the total area of land is 3.41 acre and vested land 1.71 acres. And petitioner is the recorded owner in respect of 1.29 acres, less than 50%.
So it's less than 50%.
Yes, less than. On that ground, my lord, the rejected the pair of the petitioner, my lord.
Only on that ground, Lordship, that is not the landed property, it's a water body. I have already started.
The 273 is with regard to
Lordship,
water body.
I'm bow down. I'm bow down to your Lordship, but as
So where is the illegality in the order?
no, I'm not on that point, Lordship. There is, I'm not raising any point that the order include is
You
illegal.
are challenging this order.
I have challenged, but only on the ground that stating that I have not formed any, as I am not the owner of the less than 50%, and I am not the form any cooperative society or any
Question of cooperative society arises when you are owner of more than 50%.
more than 50%.
If more than 50% of water area is vested, then it will not be settled in favor of any private co-sharers. That's the rule.
Lordship. But if they create any third party interest, Lordship, then it will, my rights will be prejudiced. As I have started pisciculture over the said water body.
The rule is very clear, sir. In case of a more than 50% lease share, the rule is very clear.
Lordship.
It can be granted only when there is no local fisher.
Only short-term benefit may be given, Lordship. Otherwise,
Can it be done? Beholds the rules. You are challenging this order on which ground? What is your ground for challenge?
on the grounds of Lordship, short-term benefit, short-term lease may be granted. Otherwise, the rights of the petitioners will be prejudiced.
So rights should be within the periphery
Ambit
law.
of the four corners of the Lordship.
So if it's divorce the law itself, the rule itself, how do you take this application?
But on the earlier occasions,
I'm
Lordship,
sorry, it has to be dismissed.
no, Lordship, the earlier occasions they granted lease in favor of my father.
If they've made a mistake in the earlier occasion, they cannot continue with it now.
For that reason, the lease was granted, Lordship, in respect of my father. That was also considered by your Lordships on the earlier
That
occasions.
is not their case, my lord. Here they have challenged this into the order, my lord.
On the grounds that my father was
that cannot be a ground, my lord.
Was getting the lease, Lordship.
They have stepped into the shoes of their father and they are asking for the same benefit.
The rule not permits, my lord.
Page 26, Lordship, kindly consider. Though it is not legible, page 27 is a legible copy. And that was not so far, Lordship, in the year 2013.
The same plot, water body was granted in favor of.
I do not have any.
Lordship,
From page 27, it is not appearing that the lease has been granted in favor of their father, my lord.
The Haji, from whom received, Lordship,
Haji.
the Haji is my father.
And my lord, how their father has been allotted, I do not know, my lord, but
it has already allotted, Lordship.
If that has been allotted, whether that.
Annex the allotment in favor of your father?
Lordship, this is the receipt duplicate carbon receipt book, Lordship, in page 26. As it is not legible, I am annex type copy along with the.
How is the allotment done? By way of a document, isn't it?
Lordship, that was also annexed as page 24, 23 onwards, Lordship. The legible copy of the page 24 is at page 25. Lease of plot number 610, area 171, classified in Pukur.
It was admittedly granted in favor of the petitioner earlier, the predecessor earlier.
That is appearing for page 25, my lord.
The same water body, the same conditions.
Once it has been granted, that does not mean that they have to face for it. Because there is a rule, my lord. How can I overcome the rule
When
273 now?
when the rule was there when this was granted?
Lordship.
How that lease has been granted, I do not know at that moment, my lord. That we do not have right now, my lord.
Please come back with that instruction.
Let me come back, my lord.
If you have granted in favor of the predecessor under the same rule,
Yes.
how can you deviate now? Rules do not prima facie permit, that is evident.
Yes, sir.
But then you have granted it earlier.
How this has been granted, I have to take instruction.
Please take instructions.
Grateful.
For learned counsels for the parties. Please, in respect of the vested portion of the water body was granted in favor of the petitioner's father by the state respondents. Stop. Upon demise of the lessee, comma, the petitioner applied for grant of fees in his favor in respect of the portion of the water body which was earlier granted in favor of his father in terms of Rule 273 of the West Bengal Land and Land Reforms Manual 1991. Stop. By the order impugned, passed on 13th January 2023, the additional district magistrate and district land and land reforms officer, Murshidabad, turned down the prayer of the petitioner on the ground that though the petitioner is the owner of less than 50% of the tank, he has not formed any fish production group as per the first proviso to Rule 273 of the manual to claim short-term settlement of the vested portion of the tank. Stop. Paragraph. It is submitted on behalf of the petitioner that lease was granted in favor of his father in respect of the vested portion of the tank. And there has been no change in the circumstances which entitles the authority to refuse his prayer. Paragraph, learned counsel for the state respondents seeks to take instructions as to under what circumstances and authority lease was granted in favor of the predecessor of the petitioner under Rule 273 of the manual. Paragraph, let the matter appear under the same heading on 16th June.
Lordship, may I make one humble submission? Lordship, kindly direct them not to create any third-party interest till that point of time, Lordship.
Yes.
But the impute order has been passed, Mother.
My
Prayer
my
has
order
been
has
considered
my
as
prayer has
protected.
already been turned down by the authority. So
Only
without
my-
that type of protection, Lordship, my interest will be.
Your Lordship only asked me to take instruction how the decision is granted in favor of the father of the petitioner.
If I'll not get,
If you do not give a proper explanation, you are bound to grant the same benefit
That
to the petitioner.
that lease is bad, but
And
now
let there be no third party interest created, nothing else.
grateful, Lord.
how their lease cannot be granted under the provisions of law, Mother.
The state respondents are restrained from creating any third party interest in respect of the water body in question till the adjourned date.
If the
Grateful, Lordship. Lordship, affidavit of service may be kept.
Affidavit of service. Rajat, affidavit of service.
Grateful.
Sixteen.
My lord, I am for the petition.
I appeal for the respondent.
This is my affidavit of service. This matter relates to unauthorized enforcement made on the land of Public Works Department. The petitioner raised complaint. On the basis of complaint, demarcation was made. Thereafter, the assistant engineer wrote a letter to the respondent number 7 for removal of the said unauthorized enforcement within certain period as per Highway Act. But the respondent number 7 did not remove the same. Thereafter, the assistant engineer, by following the provisions of the Highway Act, wrote a letter to the subdivisional officer for removal of the same. May not kindly come to page 23, the order passed by the subdivisional officer. Practically, subdivisional officer encouraging the illegal enforcement. It appears from the order. And
Wonderful order.
kindly see the order number 2.
Yes, nothing else need to be submitted. What does the state have to say?
My lord, I appeal the statement. My lord, kindly see the order. This
I've
is
seen the
our.
order. How do you justify it? You are
Yes,
supporting the encroachers?
yes,
No, not at all.
obviously.
My lord, in this regard, then I shall file detailed report to this.
What report is necessary, sir, in this
Yes.
matter? You have admitted the encroachment.
Yes.
What further, what else remains?
My
You
lord,
say that let them be there, there'll be a law and order problem. Is
Lordship,
that how the government agency
no, not at all,
functions?
Lordship. Then I shall come back with proper instruction why it has been done so, Lordship.
Come back.
Yes, yes. Give me, I shall take specific instruction.
This order is not only irregular, it is
Lordship,
illegal.
Lordship, I want. I shall come back with proper instruction.
Let him come back.
Lordship.
Practically encouraging the illegal enforcement in
Lordship, I have
violation of
also
the act.
seen that order, Lordship. I shall come back with proper instruction, Lordship.
And you will agree that this is not an order. at all.
Lordship, that I appreciate, Lordship.
Affidavit of service. Private respondent has no role to play for the time being. The order passed by the subdivisional magistrate, Tehotto, Nodia on 10th March 2022 is assailed in the writ petition. The order records that though there is encroachment upon PWD road, such encroachment is not causing much hindrance to the commuters, and removal of the same will create unnecessary agitation among other encroachers, which may result in deterioration of law and order situation. Paragraph. Learned counsel for the state respondents seeks to take instructions as to under which provision of law such order has been passed. Paragraph. Let the matter appear under the same heading on 12th June.
Lordship.
17.
I am appearing for the petition.
Yes.
The subject matter of challenge is that a memo which was issued by the Assistant Director of Fisheries, wherein he has, my lord, at page 58, wherein he has make an direction upon the in presence of the Ministry of State and also in the presence of the others, that the fish catching in flowing river Ganga in the meeting district magistrate directed that in the flowing river fish catching can be made by fishermen without providing payment to anybody. This memo is prejudice me. Why? Then, my lord, kindly come page 19.
19.
19.
Yes.
This is the lease given a particular tank fishery, my lord, in commonly called Jalkot, for the period 1424 BS to 1430 BS. Page 19 at the middle part. Kindly see the Mothabari Divot Somiti Limited for the period from 1424 BS to 1430 BS. Your Lordship, what?
No, please give me a minute.
On the middle part. Hence, the above referred fishery is provisionally settled with you, being the successful bidder, namely Mothabari Divot Samobaya Somiti, for the period from 1424 BS to 1430 BS.
Yes.
Thereafter, my lord, we made pisciculture there, and letter of intent was issued, that is at page 23.
This is for a particular area of the
particular area, yes. Then, my lord, we facing trouble for pisciculture. Then director of Assistant Director of Fisheries at page 29 wrote a letter to the Superintendent of Police Malda. An application of Mothabari PS has received at this end, and where they noticed that the mayhem at Jalkot by some outsider on 8/3/28, the enclosed copy with self-explanatory and details for kind perusal information, which is enclosed herewith. So the undersigned requested you please take necessary action for your end to maintain law and order.
Then, my lord, in spite of that letter from the authority, my lord, we facing the same problem. Then we move before the Honorable High Court at page 33. Yes, Page 33 is the order of the Honorable High Court. I'll read.
Let me take my break.
The Honorable High Court passed an order that is at page 36, wherein they have directed the relevant page is 37. In the fact of the present case, it appears that the petitioner is enjoying a lease from the government. The petitioner is entitled to act in terms of the lease and enjoy the same in accordance with law. The police authority are obliged to protect the right title interest of the petitioner as a lessee of a lease granted by the government. There is a request of the additional district magistrate to the superintendent of police as contained in the written dated November 30, 2018. In such circumstances, the police authority are directed to render adequate police assistance to the petitioner in accordance with the writing of the additional district magistrate dated November 30. Then I'll let
Hard. But the point is here very short. My lord knows that maxim, the lessor is to protect the interests of the lessee. Ullas Act, but this is a passage. My lord has shown. Here, my lord, the lessor under 272 give a lease to me. And now what they're doing? The same person, they're saying that everybody can catch fish. Totally frustrating my leasehold right.
You have been given in respect of a particular portion.
That portion has been given. The notice can come to page 58.
58 says entire.
Entire stage. So this includes my leasehold interest. That's the sum and substance of my grievance. Whether that can be done.
My lord, first of all, my lord, there was a lease on the basis of making payment of rent. Let my landlord show any for 6 years he is using the Jalkar without making a single farthing.
But this is the ground.
Yes.
Is the ground they are saying.
Now what
Where
is
it has
your
been
right?
said, this is the ground.
What
I
is
am
your right?
terminating your lease for non-payment.
What steps have you taken?
My lord, steps has not yet been taken because the term will expire, my lord, with 31st Chaitra of 2014-30. That means in 24, 13th April 24.
Then are you entitled to lease it out to anyone else?
My lord? My lord,
The lease subsists till 1430.
yes, 24 up to April 2030. But he has not paid a single farthing.
What steps have you taken, sir?
My lord?
What steps have you taken? It is acquiescence on your part. You are allowing them to continue without payment of.
My lord, several notices requisition has been given. Please make payment. Please make payment. Nothing is being made.
So that please make payment has not been adhered to. What steps have you taken?
My lord,
After that
next
you have
course of
allowed them
action. Next course of action will be taken, my lord.
Till now you have not taken.
Yes.
So it is acquiescence on your part. You have allowed them to continue. So can you allow others also to continue on this in the same leasehold area?
My lord, in the
Lower your situation problem has come up. Everybody is allowed. And
Yes.
asking for money.
my lord, this is not for this year 23, but from last 6 years. Last 6 years,
Sir, repetition will not really help. I'm sorry.
my lord.
It will be set aside to the extent.
And my lord,
Uh,
with the liberty to take appropriate action in accordance with law.
Prevent you.
action for what?
My lord,
Your repetition.
for making payment or other, what course of action would be taken?
It's not the lease.
You are at liberty.
My
This
lord.
court will not deal with that part. This is not your repetition, sir.
টাকা দেবে না শুধু মাছ লুটে খাবে।
It is only when such an allegation has been raised that you're coming up with this point, isn't it?
My lord, My instruction is that, my lord, he is not making payment.
So far as the leasehold area is concerned, the order will be set aside.
Yes.
Not the entire Ganges.
Whether, my lord, if you logically recall, my lord, specific relief act, whether this order can be implemented, this is a river. Can it be implemented? There is no demarcation.
This is the entire Ganges.
Entire Ganges has been given, and my part has been earmarked, and that has been given to me.
So let nothing happen in the portion allotted to the petition. Yes.
My lord, this, my lord, the page 58. Page 58, my lord, is not, my lord, reasonable order. But other thing, my lord, on the part of the petitioner, he has to, my lord, some bona fide.
Shall I record your submission?
What is the malafide? No, kindly don't do that. Then he will be in trouble.
Because I don't have to give any explanation at all. Just a line that he says it's not a reasonable.
Then nothing, my lord is relieved. But
nothing else remains.
then he will be in problem. My friend will be in problem.
Counsels for the parties. It is contended on behalf of the petitioner that the petitioner was granted lease in respect of a portion of the water body comprising what is the area? Islampur, Jalkor.
এরিয়াটা দেখা আমাদের লিস্টে বার কর পেজ
19.
Page 19.
19 is not very clear.
Yes, page 19, my lord, get the area. But the handwritten portion is the area.
Gangapat, Islampur,
Jalkor,
Comprising what?
RS 557.
Being Gangapat, Islampur, Jalkor, 557, RS, what is RS area?
RS area.
The RS plot number, that is
Plot,
557.
probably it is subsequently gone to the Ganges. Previously it was land. And the area is Manik Chowk to Narayanpur.
RS area, comma, Manik Chowk,
Narayanpur.
Then
Ujan Rajmahal
Ujan Rajmahal.
to Gopalpur.
Manik Chowk, Narayanpur, Ujan, within bracket, Rajmahal.
It is written, eligible.
19.
I have handed in this. If you logically look to
To
this.
Gopalpur.
যদি পড়তে পার that is written in
My lord, page 2, my lord, page 26B.
ওই একই পড়া যাচ্ছে
Page
What is EB? The return gen.
my lord,
East Bank, maybe East Bank.
my lord, page 26B, my lord, the legible.
এই তো এটা আছে তো এটা তো 26 দিয়ে তো বলা আছে
Gangapat,
26 is
Islampur,
eligible
তারপর করুন দাগ নাম্বার
আমার
557
কাজ করে দিয়েছে এটা ভালো কাজ
RS.
ওই বলে দিলি এটা
টাকাটা দে, তা নাহলে টার্মিনেট করতে বলে দেবো। টার্মিনেট করতে বলে দেবো।
To Gopalpur,
মাছ ধরবে টাকা
East
দেবে।
Bank,
may I have my lord's kindly
East Bank.
may I have my lord's kindly
If your lordship kindly 26B, in Bengali it is legible. The leasehold area.
For a period of from 1424 BS for a period of a category from 1424 BS to 1430 BS. The petitioner was unable to carry on pisciculture in the said area due to resistance of local people, for which the petitioner filed a writ petition being WP number 3997 within bracket W of 2019. Stop. In an order passed on 22nd February 2019, comma, a coordinate bench of this court observed that the petitioner is entitled to act in terms of the lease and enjoy the same in accordance with law. Stop. The police authorities are obliged to protect the right, comma, title and interest of the petitioner as a lessee of a lease granted by the government. Stop. The police authorities were directed to render adequate police assistance to the petitioner in accordance with the writing of the additional district magistrate dated November 30, 2018, 30, requesting the superintendent of police to render such assistance. Stop. Paragraph. The petitioner complains that by an order passed on 16th March 2023, comma, the Assistant Director of Fisheries, comma, Malda, by an order in a letter, by a letter issued on 16th March 2023, the Assistant Director of Fisheries, comma, Malda, informed the Block Development Officer, comma, Kaliachok, that the district magistrate directed that the that catching of fish in the river Ganges can be made by fishermen without making any payment to anybody. Stop. The petitioner complains that the said order has affected the interest of the petitioner in terms of the deed of lease executed in their favor. Paragraph. Upon consideration of the submission on behalf of the parties and material on it is submitted on behalf of the state respondents that the petitioner has been carrying out pisciculture in the leasehold portion of the river without payment of lease rent till date. Paragraph. Learned counsel for the state respondents has not been able to apprise the court as to what steps or what steps have been taken by the authority for such alleged breach on the part of the petitioner, or whether any step has been taken at all. Paragraph. Be that as it may, comma, since the petitioner is enjoying the right of pisciculture in the portion of the river leased out to him by virtue of the document issued on 27th February 2018, which is valid till 1430 BS, comma, the order impugned, the letter impugned recording an order of the district magistrate. The letter impugn dated 16th March 2023, recording an order of the district magistrate, ought to be set aside to the extent of the area covered by the lease executed in favor of the petitioner. Paragraph in view of the above. The letter dated the order of the district magistrate directing catching of fish by fishermen without making any payment to anybody, communicated by the letter dated 16th March 2023, is set aside to the extent of the area leased out to the petitioner the day document executed on 27 February 2018. Since this court has directed the police authorities to render adequate police assistance to the petitioner in order to enable the petitioner to act in terms of the lease and enjoy the same in accordance with law, it is expected that the direction of this court shall be complied with in its letter.
Well, subject to payment of the cost.
That is your case, sir. There is no
Already.
document. I have stated in accordance with law,
In accordance with law, yes.
in its letter and spirit. Disposed of, judgment.
Deeply obliged.
Deeply obliged.
Lord, 18, I am appealing for the railway authority, Lord.
May I file the affidavit service?
Municipality, state,
I have solved all.
They are not.
I have solved all, madam. Yes.
state.
Earlier occasion, Mr. Dey, your lordship engaged Mr. Dey. Or may I place
Please
this?
serve a copy.
Yes, sir. This is second round of litigation, madam. Matter relates to NOC, issuance of NOC from the railway authority. I moved the writ petition, your lordship directed the respondent number 2 to pass, consider my representation and pass reason order. They have considered representation and passed the reason order in my favor. And they said, NOC can be given subject to submission of certain documents. I have submitted all documents. Still now, they have not issued the NOC. When my lord, as per their guideline, 60 days is the total time for issuance of NOC.
Where is the order? Page
Yes, my lord.
41.
Page 41.
The state
At
has
the
no role
bottom.
to play.
Yes, my lord.
The state has no role to play here.
State has subsequent role, issuance of NOC from the BLRO conversion and permission from the municipality. Or for NOC, they have no role.
একই ম্যাটার দাদা, হ্যাঁ সব একই ম্যাটার।
হ্যাঁ This is the order. But I submitted all documents at page 43, my lord. And thereafter the documents, building plan and etc. My title. Again, when I made a demand, even then they are silent.
My lordship may kindly have a look to my lord page, as your lordship was looking at page 41. My lord, why this my lord was turned down? Lordship kindly consider my lord this. It was not turned down, giving him an opportunity.
Documents are called.
Certain documents have to be produced, which my lord he didn't produce my lord at the time of hearing. My lord, in spite of your lordship's direction, my lord, lordship may kindly consider page 41 bottom portion, my lord.
Yes.
3 documents are required, my lord. Clear title deeds, my lord, a sketch map, my lord, as per my lord the railway works manual, my lord, provision is 827. My lord, I'll come to that later on. And my lord, the structural stability certificate, which my lord they couldn't produce at the time of hearing. Now, my lord, after that, my lord, they filed a representation, my lord, at page 43.
They have produced the documents on 28th November.
28th
By
November,
this
Page
representative,
43.
page 43. Now, lordship kindly consider, my lord, one thing. My lord, it is only because of them, my lord, it could not be disposed of. If your lordship directs, my lord,
The 28th November also it could not be disposed of.
my lord, 28th November, my lord, they have filed.
They have
But my
complied
lord,
with
the
your direction.
yes, lordship kindly, my lord, direct us, my lord, to dispose of, my lord, his representation on, my lord, submitted on
There is no
28th of.
question of disposing of. You have to allow, you've already allowed it.
No, my lord, we have, my lord, subject to correction, my lord, we have not allowed. Lordship kindly consider page 42. My lord, as such, the concerned petitioner doesn't fulfill the conditions and criteria as laid down in paragraph 827 of the Indian Railway Works Manual. It is a specific finding circulated through railway boards memo number so-and-so dated so-and-so. In view of the above, the undersigned came to the conclusion that the case of the petitioner may be considered on submission of relevant documents and on fulfilling the conditions prescribed under the rule.
this part.
So, my lord, these two things, my lord, they have to satisfy.
I have a
First of all,
complaint.
my lord, they have to file all the documents. And my lord, second of all, my lord, as per the railway manual, lordship kindly consider for a moment.
Yes.
my lord,
Paragraph
they have annexed.
7 of the railway manual. What is it?
Yes.
Yes, lordship kindly consider page 30 for a moment. My lord, may I just read, my lord, it's not a longish one, but my lord, I'll just take your lordship, my lord, to the relevant portion.
Page 30?
Page 30.
Yes.
My lord, in the first paragraph, your lordship will find that, my lord, there is, my lord, approximately 3 meters, my lord, space, open space is required. My lord, about, my lord, 6th line from the top. My lord, this is the mandatory, my lord, space they have to, my lord, keep. Number 2, lordship kindly consider, my lord, paragraph 2, my lord, rule 2, I am not relying on because these 3 conditions, my lord, they have submitted documents. But lordship kindly consider rule 3. After receipt of the request, the site verification is to be done by the field units. Field officials should check and certify the width of railway land and distance of plots from the railway boundary. Rail level, ground level, etc. shall be taken. Sufficient open space be left between the railway boundary and the nearest edge of building to ensure that it will not result into accrual of various easement rights as mentioned in para 1 above. Plot should be marked in the sketch with reference to kilometer post and permanent structures railway land, which shall be verified with the certified land plan. Thereafter, my lord, lordship kindly consider 4 a drawing showing all the aspects as mentioned in paragraph 3 above and other aspects like drawing arrangements, access arrangements of building, height, length, width. My lord, these all conditions have to be fulfilled. Then, my lord, comes paragraph 6, rule 6. The proposal of NOC duly approved by DRM should be sent to headquarters. The plan should be signed by CEG, SAG officer dealing with the subject in headquarters is taken off his approval. After approval of CE and SAG officer dealing with the subject of the headquarters, one copy of the plan be kept in headquarters and record an original plan be returned to him. So, my lord, these are the conditions he has to satisfy, and then, my lord, total within 60 days time limit will dispose of.
Now, my lord, there is a specific finding, my lord, he has not complied with this rule. So, my lord, my humble submission before your lordship, my lord, the lordship may kindly come to the plan they have annexed, page 45. My lord, this plan is also your lordship from the plain reading of this plan, your lordship will get, this is not, my lord, in accordance with, my lord, rule 3, my lord, as my lord, I have shown to your lordship. So, my lord, all these, my lord, have to be complied with, my lord, by way of a composite, my lord, representation. Not in, my lord, this fashion, my lord, as they have done in piecemeal manner. My lord, even at the time of hearing, they couldn't produce. So, my lord, my learned friend's submission that we have allowed, my lord, my respectful submission, we have not allowed. Because of, my lord, this non-fulfillment, my lord, his prayer was rejected, but with a giving, my lord, a liberty to him, my lord, to approach again.
No, no, my lord. My lord, kindly see the
Lordship,
order.
kindly see the order.
They cannot deviate from their own order, my lord. Consider own submission of relevant documents.
And on fulfilling conditions prescribed under the rule.
Yes, but they are sitting tight over 4 months, 5 months. Now they are showing the difficulties.
No, no,
Let
it
them
is-
call us with the original.
Order itself says that you have
Yes.
to fulfill the conditions.
Man, I have submitted documents.
That is one part. What about the
Yes.
second part?
Well, let them inquire. But this is not my
How
duty
long
to
should
inquire.
you come to dispose of?
My lord, I will dispose of within, as 1 month.
1 month?
My lord, let him, my lord, approach first with complete detail, because, my lord, for the purpose of, my lord, convenience of his client, my lord, I am saying this, because, my lord, as I find, my lord, as of now, my lord, his representation, my lord, is not in compliance to, my lord, the 827, my lord, Railway Works Manual. My lord, it would be better if he comes up.
It is not for the petitioner. It is for you to inquire.
Yes, I will inquire, but, my lord, lordship, kindly consider, my lord, rule 2, my lord, the open space, my lord, 30 feet, my lord, as I have pointed out at page 30, my lord, may I just, at the cost of repetition, my lord, may I just indicate, page 30, first paragraph, lordship, kindly see, my lord, the open space of 30 meters.
The petitioner will not do anything. You have to.
My lord, we'll check up, my lord, subject to, my lord,
hold a joint survey and see that it is complied with.
yes, we'll do that.
No, open space 30. This is my case. Or kindly see, my lord, para 8 of
My
the
lord, this is
para
only
9
for
of
the
the
purpose of.
He's referring to page 30.
Page 30. Their submission is there should be 30 meters
Because
space.
paragraph 827 is the duty and role of the railway officials.
Yes.
My lord, we'll check, my lord, provided, my lord.
Can at best cooperate.
Yes, my lord, the plan, my lord, which I have indicated to your lordship, doesn't, my lord, indicate, my lord, or complied, my lord, rule 3. My lord, as I have indicated just now at page 31. My lord, the plan, my lord, they have annexed. Lordship, kindly see for once.
You are pointing to the sufficient open space.
Yes, open space, and lordship, kindly see, my lord, the distance, height, and, my lord, the width. These are to be specifically mentioned there. Then, my lord, we can ascertain from field inquiry. My lord, subject to correction, they have not mentioned. Page
No,
45.
my lord, this is not my case.
They are not to mention, sir. After receipt of request, the site verification is to be done by the field units.
Yes,
First
we'll do
line.
that. We'll do that.
Then the
Then
field
lordship,
officials should check and certify the width of the railway, etc., etc. So it's the entire responsibility is upon the field officials.
very well, lordship, kindly direct us. Within 1 month, we'll do that.
You're completed.
On the basis of
No, one
this.
thing, my lord. Their prayer is, my lord, there should be 30 meter space. But this is not the case. Para, my lord, our initial prayer was either issue the NOC from land situated within 30 meters or acquire the same, if the land is necessary for the railway. Kindly see the para 9 of the circular. But they have decided, no, we will not acquire, we will issue NOC. Now the space of the question doesn't arise, my lord. Para 9, my lord, specific.
Page 32.
Page 32. As regards compliance of provision of development control regulation or other rules issued the state, it is for the state government, local authority to examine and ensure compliance of the same. The provision of IRWM, Indian Railway Manual, my lord, are not meant to unnecessarily restrict the utilization of the land adjoining railway land on the plea that such land may be required for future development of the railway.
This is regarding development control
in
regulation.
case land is required by railway at a future date, it is only fair that Same is acquired after paying due compensation. Let
But
them pay.
Development control regulation is a state subject.
Either they have to issue NOC or they have to acquire.
They have agreed to issue NOC.
Yes.
Upon such a certain terms and conditions.
Yeah.
They have to comply with this 857.
A 30-meter space cannot be their ground, my lord. My prayer is NOC within 30 meters. But my land cannot restrict by the railway.
Let them consider upon field verification.
Consider they will.
I cannot give a direction. These provisions have to be complied with.
But,
Para 827 has to be complied with before granting grant of NOC.
granting NOC, but
Milord,
there
the purpose of Milord, this is only Milord, so that Milord
Can utilize the land.
yes, and Milord, it is not encroached. That is also written Milord in the
yes,
manual.
so that I can use the land freely. This
Affidavit of service. None appears for the state respondents and the chairman Arambagh municipality despite service. Paragraph, Mr. Dev, who is present in court and usually the regular is court, stated. Copy service copy service direction.
সুন্দর একটা যে ইসে নিয়েছে আমার সাথে একটাই দিয়েছে আমাকে আর কিছু দেয়নি এটা নাই তো আছে
The petitioners submit that
ছিল তো
they are recorded owners of the plot of land in question. Which is situated on the southern side of Howrah to Goghat railway line near Arambagh railway station. The petitioners intend to the petitioners applied for conversion of the land from Shali to Vastu for the purpose of raising construction of a multi-storied building therein and applied for issuance of a no objection certificate from the railway authority for the same. Stop. By an order passed on 4th August 2022, the senior divisional engineer within bracket 1, Eastern Railway / Howrah, disposed of the application filed by the petitioners with an observation that the case of the petitioners may be considered on submission of relevant documents and on fulfilling the conditions prescribed under para 827 of the Indian Railways Works Manual 2000. Stop. The petitioners submitted the documents as called for by the authority by a letter issued on 28th November 2022. Stop. No further step has been taken by the authority for issuance of no objection certificate in favor of the petitioners. Paragraph, it is submitted on behalf of the railway authorities that the prayer of the petitioners shall be considered by the authority upon verification of the documents submitted by the petitioners and complying with para 827 of the Indian Railways Works Manual 2000. 827 of the Indian Railways Works Manual 2000. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent.
My lord, the actual respondent is not a party here. My lord, Senior Divisional Engineer 1, Eastern Railway is the authority. As your lordship will get it, my lord, at page 42.
But hearing was conducted by the DRM is the authority. One kindly see the circular also, guideline, in the guideline. General Manager,
Guidelines, this is by the Director Railway Board.
Yes, my lord, page 42, lordship kindly consider directs, my lord, Senior Divisional Manager. My lord, as he has disposed of this, my lord, already by way of a recent order.
Why don't you add him as a party?
yes,
Let him be included as a party, let him be.
but he conducted hearing on behalf of the DRM. Your lordship earlier occasion directed DRM to consider. He considered on behalf of DRM.
DRM is the second respondent.
Yes.
Let him consider. Directing the second respondent to consider and dispose of the prayer of the petitioners requesting issuance of no objection certificate in their favor within 1 month
Lordship.
from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, and
My lord, may it be 6 weeks because the field inquiry is also required.
6 weeks. Within 6 weeks. And in the light of the observation made in the order passed on 4th August 2022.
My lord, only one humble
But
submission.
in
My
the
lord,
event, my
lordship,
lord, that should be there, my lord. Otherwise, they will take another time.
In the event,
In the event, all my records are found genuine, and then let issue the NOC.
my lord, my learned friend cannot preempt, my lord, all these things.
I have directed them to
Consider, they will consider and see.
My lord, let it be on merits, my lord, as your lordship has directed, my lord, we'll see, my lord. If it is on, my lord, as per, my lord, the compliance.
If they find it to be correct, they'll the natural
No,
consequence is
natural, non-naturally, my lord. Your lordship knows one better than me.
paragraph. In the event the petitioners are found entitled to the no objection certificate, comma, such certificate be issued in favor of the petitioners within 2 weeks thereafter.
Get.
Yes.
My lord, only one thing, my lord, your lordship has recorded my submission, my lordship, let it be court's order, my lord, then, my lord, it will be create some problem. My lord, in the earlier paragraph, lordship has, my lord, recorded my submission, but
His submission record position. I don't think so. That. That is the observation of the order itself.
yes, lordship, let it be
I've
court's order.
recorded that.
My lord, let it be court's order. Entire burden will be on my shoulder. My lord, my humble submission. My lord, let them consider, my lord, in accordance with 827.
Your lordship quoted the recent order.
No, I'm
I would have made your recorded your submission in terms of the order itself, nothing extra. Whatever is stated in the order of recording.
grateful.
And up to 22, same issue. Item number, after 22.
Please.
Yes, yes.
19.
Same matter.
No, my lord, it is not the same. It's not the same.
Here for the railways,
Yes, ma'am.
state and others.
My lord, subject to lordship's kind sanction, my lord, it's a petition in respect of the
Let the
Somor.
petitioner make it sufficient.
Yes.
The affidavit of service.
সমর কুন্ডু তো এটা? আচ্ছা।
So they may I request you in this matter also. Yes. You say it's the same issue.
Yes, issue is same.
My lord, according to his instruction, the issue is same. Now, my lord, kindly come to the cause title of the petition.
Yes.
My lord, it appears that the petitioner before your lordship is one Somor Kundu Bappaditya Kundu
Yes, and Shonali Shet.
and Sonali Shet. My lord has got it. Now, my lord, 2015, Sonali Shet has purchased the property. Now, my lord, thereafter they have approached this court, filing an application. The order has been passed by this honorable court. That was, my lord, on 29th November 2021. On the day, my lord, there was an observation, specific observation by your lordship, and that was directed to consider everything. Now, my lord, on the day when 4th August 2022, my lord, when it was considered, my lord, same issue we have dealt with, that these things are required. Now, my lord, on the day of hearing, there was nothing. They couldn't show even the title deed, structural stability certificate, as well as we have requested lastly that within 60 days, if it is possible, let them produce all these documents.
Where is
Now,
it stated that within 60 days?
no, my lord, here, my lord, kindly come, my lord, if your lordship kindly sees, that is page 45.
Yes.
Page 45, my lord, just I am reading, my lord, first paragraph, second, third, fourth, fifth paragraph.
Yes.
As per above mentioned circular, applicant has to submit following documents along with the request letter for duly forwarded to the state government authority of the concerned divisional office. Clear title and of the land in favor of the applicant supported by all related documents.
Identical order.
Identical order. These are the things that has been submitted. Now, my lord, what they have done, they have obtained the structural certificate that is at page 49, 24th November 2022. Even, my lord, when the order was passed by your lordship in the year 2021, and they have prepared the same in the year 24th after 1 year, and the certificate has been issued, my lord, page 50, if I am not wrong. This is to certify the single-storied building plan prepared and drawn by in the name of Samim Hossain, Maya Khatun, who are not the petitioner before your lordship. And it has been signed, and the structure showing that the stability certificate, that is nowhere connected with the petitioner itself. My lord, subject to your lordship's kind sanction, Samim Hossain and Maya Khatun, they are not the petitioner before your lordship. For such reason, I have indicated initially, that means the document which has been annexed even before the court, that is not correct also.
Let the petitioner respond.
Yes.
Yes, my lord. My lord, they are a subsequent purchaser.
Who is subsequent purchase?
Who have submitted the documents.
If that is so, then my lord, petitioner, what is his locus to file the writ application before this court?
This is my fault. This is admitted in my fault.
Let it be dismissed as withdrawn then.
This is withdrawn. Yes.
Will withdraw?
Yes.
I'm grateful.
The affidavit of service. Sir. The petitioners seek to withdraw the writ application on the ground of certain defects detected therein. Paragraph in view of the above, the writ petition being WPS as such is dismissed for non-prosecution. There shall however be no order as to costs, urgent certified website.
I'm grateful.
Twenty.
This is similar to 18, my lord.
And I appear for the respondent, my lord. This is a case where your lordship will find that once they came before your lordship's court, your lordship directed to dispose of the representation, that was final order was passed. Against my lord, after the order is passed, they have provided some document and made a fresh representation. Your lordship kindly direct that representation to be considered in accordance with law by the my lord.
On the same order, sir.
This
As
should
per
be,
their recent order, I have submitted documents.
and in the approval authority is the DRM.
Yes.
My lord, your lordship will find, my lord, your lordship kindly direct DRM or its delegate.
Here, other. Earlier, madam,
Because
directed here.
approval authority is the DRM.
Yes.
না ডিআরএম এ তাহলে তখন কন্টেম্পটের প্রশ্ন আসবে, বুঝতে পেরেছেন না? হ্যাঁ, সেইটা জজ সাহেব বলে দিলে সেটা আরো সুবিধা হবে। না করলে যদি ডেলিগেটেড থাকে, ডেলিগেটি হয়ে গেলে no, similar to আমি ওটা চাইছি খালি delegate.
So let the same order be
Yes,
passed.
madam.
Only my lord, I am asking, praying before lordship, my lord, DRM or its delegate to consider. Delegate to consider.
Their official system, my lord. Lordship. Here is the party.
Approving authority is the DRM. That is why my lord, I am praying before lordship, my lord, DRM or delegate.
You are saying DRM or his
Yeah, delegate. Delegate.
delegate. 18 এর মতন same order হবে। অনেকগুলো আছে।
না 19 আমি নি।
Directing the DRM যেখানে বলেছি।
20টা তো হলো তো।
DRM / is delegate. In 18 also I'm adding this DRM / is delegate.
No, that would be better because DRM is the approval authority.
Same order.
Grateful to us.
Mr. They regularized.
Hey,
21.
same order. পরেরটাতে না জুনিয়র নেই কেউ, ঠিক আছে, only আমি।
The dates are also the same, I find.
Yes, yes.
22.
Don't also same.
22 also, Mr. Mashu. Mr. They regularized in all the matters. 19, 18, 20.
23.
23, my lord.
22, my lord, I am for the response.
Same order.
No, my lord, not same.
20.
22 হয়ে গেল বললো?
22 হয়ে গেল।
ও আছে তো, ভুলে গেল, হয়ে গেল তো।
না না, এক হলে আলাদা।
20.
ভুলে গেল, হয়ে গেছে।
My lord, kindly,
What is the difficulty?
my lord, according to the petitioner himself, they have not submitted the entire documents what have asked by the railway authority. They have admitted under paragraph 6.
Yes.
And my lord,
They have submitted it subsequently.
yes, no. In the writ petition paragraph 6, they have submitted that according to the earlier direction, railway considered their representation. And in that representation, my lord, considering at the time of consideration of representation, railway directed to submit some documents.
That was not submitted and same is admitted in paragraph 6 also.
That was submitted, page 54.
My lord, kindly see the paragraph 6 of page 4, my lord, writ petition. Your petitioner further states that per para 2.0 of the said guideline, your petitioner will definitely submit the necessary documents mentioned as and when the same will be asked by the railway.
These are other documents in terms of the rule.
Yes. Kindly then,
Go
my,
to page 54.
yes, my lord. Then, my lord, kindly come page 42, my lord.
Yes.
That is the guideline. And my lord, according to the Railway Boards Act 1905, each and every guideline of the issued by the railway that has the statutory force. According to the section 2 and 3 of that act, my lord.
I am not on merit, sir. Let the railway consider.
And my lord, kindly see paragraph page 52, my lord.
Yes.
What documents railway asks, my lord.
Yes. This is identical to all the earlier matters.
So, my lord, my only submission, two submission. One is, my lord, according to the railway requirement, they have not yet submitted the all documents as stated in the letter dated 4/8/2022.
They have submitted, sir. Please come to the next page.
Yes, my lord.
Page 54.
Yes, registered deed of land. My lord, kindly see who has submitted that. I don't know who is Jagannath Maji.
Petitioner number 2, well, he has not seen the petition.
Yes.
Yes, my lord.
Same. And this court is not on merits.
And the main problem is that is the 30 meter is the main problem. The 30 meters provision of open space, that is the, my lord, the main problem.
Hear out the petitioner, deal with it.
Either they issue NOC or they acquire. But as their guideline.
No, my lord, then they have to come with an fresh writ petition, my lord. His prayer is not for acquisition.
Yes. But the first read
No.
petition was either.
No, kindly see, my lord, the prayer.
My lord.
This writ petition.
Yes, earlier.
There is
And earlier, what was the direction of the earlier?
by your authority that it need not be acquired now, let it be utilized.
My lord,
There is a communication.
provision of acquisition is separate same from the provision of, my lord, the issuance of no objection.
They have to
That is the.
their own guideline.
Yes, my lord.
Anyway, let it be considered. It is the
The
observation
guideline
of
says
your authority.
they cannot restrict amount.
And if it is required
Yes.
on a subsequent date, it will be acquired in terms of law. Now let it be utilized by the petitioner. That's the observation of your authority.
And while the appropriate authority is the Senior Divisional Engineer 1, Howrah Division,
In the other matters, your authority says it is the DRM,
not the DRM, my lord.
DRM or his delegate.
No, not the DRM. DRM is the highest authority of the division. But my lord,
DRM or his delegate.
regarding any land related matter, the Senior Divisional Engineer is the appropriate authority. And my lord, in this particular case, Senior Divisional Engineer 1.
This is very difficult, sir. All of
Yes,
you say
that I know,
different
my
things.
lord, that in every land related matter of the railway, Senior Divisional Engineer is the appropriate authority.
Let
my
him delegate. Let the DRM delegate. I'll record as DRM and his delegate.
DRM is the highest authority of the division.
He has to delegate, isn't it?
Yes.
DRM / his delegate. You go. Huh? Same order. Huh. The dates are also the same, I
Yes.
find out. Let the authority decide.
This is-
24,
22.
One of these separate matter, my lord.
23.
One of the land was requisition and thereafter scheme abandoned. In spite of that, my lord, the authority is sitting tight on the matter. I am entitled to get release of land and this is covered by your lordship. My lord, kindly see, my lord.
Ashwala. 23. There are 23, isn't it? 23.
But this is covered by a lordship. And kindly see,
What is the matter about?
a land was requisitioned under Act 2 of 1948 for a particular scheme. This scheme subsequently abandoned. In that case, I am entitled to get return of land and requisition commission damages. Your lordship was similar order in several matters.
You filed a representation.
Yes.
That is the last.
Kindly see your lordship order, my lord.
Page
Page 35. Same issue and same scheme, my lord. Your lordship order. Page 35 is the representation and date of representation is 37.
Mr. De,
Yes, madam.
consider. Same order. Page. Devich. The date of representation is, huh?
10th of May 2022.
There is no date.
10th of May.
10th May
2022.
2022. Date of representation. 10th May 2022. Three months.
Same order. Get
24.
next one is similar. Date of representation also similar.
Same.
Yes.
Same order. Individual service charge. You are filing the affidavit of service in this
Yes, ma'am.
order
Yes.
also?
I-
25.
Made to Lord and for the petitioner, my lord. Deputy, sorry, dear. Lord, here, my lord, an order was passed.
Have you served?
My lord, yes, yes. Order was passed by the collector, my lord, district magistrate.
Who is appearing for the respondents? Respondent number 8 is Syed Ajijul Hussain.
My lord.
The service shows it has been delivered to Indian Bank. How?
No.
375. 375. Do you have a copy of the track report? Please find out. The last track report?
That report,
How does the bank come into the picture?
Ajijul Hussain, ঠিকই আছে 375 W. Ajijul
Yes.
Hussain, private party.
My lord, the order.
How is it served on the bank?
No, there is a bank.
There is a bank.
Possibly bank. I don't.
Syed Ajijul Hussain cannot be a bank.
No, no, no. My lord, then will kindly come the.
Please serve and come
Postal
back.
receipt. Postal receipt contains the name of Ajijul Hussain.
Yes, but the service is on bank.
Report.
Item delivered to Indian Bank.
Ajijul Hussain.
The postal receipt contains that name.
Please come to the track report.
Tag report of
That report contains
number to the tag report of the
Indian Bank address.
Who is Indian Bank?
What can?
no.
Please serve and come back.
No, what happened, my lord? May I take this, my lord? 1 minute. My lord, the order was passed by the collector, district magistrate, under section 4 of the West Bengal Public Land Unauthorized Occupant Eviction Act. That is applicable. That order was challenged before this honorable court. It appeared before your lordships. Next page. Page, my lord, 38 of the writ petition. No. Page 37. Your lord, as it is applicable order, your lordship is giving liberty to the petitioner to prefer an appeal under section 7 of that act, and it was withdrawn. Then the next page, my lord, having liberty and also prefer an appeal before the divisional commissioner. When that is pending, appeal is pending, then pursuant to the order by the district magistrate under section 4, the impugned order, page, my lord, page 39. Appeal is pending. Now the subdivisional officer writing the letter for eviction and also wrote, copy is forwarded to the BLLRO and also the station manager to cut off the electricity and to demolish the matter. The appeal is pending there. So it is urgent, my lord. So I mentioned the matter. My learned friend mentioned the matter.
Will you come back next week? Can you complete service by next week?
My lord,
Yes.
what I am praying, my lord. Your lordship can give order of status quo. Because appeal is pending, admittedly, my lord.
That will amount to disposal of the writ petition itself.
No, my lord, for a limited period.
Can you come back on Monday
Monday,
after service?
Service within a 1 day. My lord.
Then any day in the next week, either pass an order or any day next week, my lord. Fix it in the meantime.
Before service is complete.
Yes,
cannot
yes, I
pass.
agree. Yes, my lord. It is our how it is.
I do not know. Will you come back on 17th? Wednesday?
17.
Yes?
Yes. My lord, 16. My lord, kindly on 16th, kindly.
16th?
Yes.
Can you complete service by
That's the
16th?
time or 17th, then 18th. My lord, kindly keep it 18th.
18th?
Yes.
Affidavit of service. Since service upon the private respondent is not complete, let the matter stand over till 18th May.
Deplorable to law. Yes. I'm deplorable.
26.
I'm for the petitioner.
Now, my lord, the complaint of your petitioner is that by the side of the land of your petitioner, there is the PW road, and there is a small passage, the private respondents are obstructing that passage, so that I am not getting free ingress and ingress to the main road. Now, I made a complaint at page
Have
31.
you served the private respondent?
Yes, my lord.
The panchayat also?
PWD will be the
So you have impleted the
impleted them, but a PWD, it's the PWD
You
road.
want to expunge?
That আমারটা হচ্ছে না আমি আছি স্যার But after filing of the writ petition, my client has received this letter, from the authorities. If your lordship would kind enough to peruse this.
Panchayat has not been served.
Panchayat, PWD.
So will you
I'll
expunge?
expand. Yes, definitely.
Private respondent has also not been served. It's item dispatched.
তাহলে কি করবে? It's proceedings have to be initiated only. I'm not praying for any mandatory order.
I understand, but private respondent has to be served. Please serve and come back.
সেগুলো
It's item dispatched.
It says, it has now returned back.
Yes?
The articles, sent to private respondents are returned back.
No, here it's item dispatched
No, it has subsequently returned back to my learned junior.
with what's the endorsement?
Insufficient address.
You have to send it again, simple. Since service upon the private respondent is not complete. Shall I expunge Panchayat?
Not required. Panchayat not required, my lord.
I'll expunge.
ওটাই করে দাও।
প্রথমে করুন on
First
prayer
একটা
of the
correction করে দাও।
petitioners. The name of the Panchayat Pradhan, Hatkhola Gram Panchayat, comma, being the 11th respondent herein, is expunged from the cause title of the writ petition. Paragraph, the cause title be amended accordingly. Paragraph, since service upon the private respondent is not complete, comma, let the matter stand over till 13 June.
May I take back the letter, my lord?
Yes, yes.
সার্ভিস করতেও পারবে না এর মধ্যে। হ্যাঁ হ্যাঁ, কস্ট আইটেমটা কারেক্ট করে দাও।
Lord, I am for the petition. This is not under section 10 of the Lord Highway Act for removal of the Lord unauthorized construction.
Private respondent?
But this is not refused to take.
My lord, on the my lord cause of action, my lord, petitioner got an order. Contempt filed,
But
my lord, contempt is pending, my lord.
But I am
In spite of that, they have filed this
I am
application.
submitting then. Your lordship kindly, earlier occasion, I came before your lordship. Your lordship directed to consider the representation and disposed of. They did not. Then, Lord, I came with a contempt application.
Yes.
Now, your lordship kindly see page 25, almost last page.
Page 25?
Yes, this is the report submitted by them. Now, your lordship kindly see paragraph bottom, para 11. The sub-divisional officer, Baharampur Sadar, passed an order sheet 2nd January 23, calling a hearing on 31st January 23 at Omuk. Next, lordship kindly see para 12. From aforesaid happenings, this is to conclude that whole process of removal is in motion and there is no latches for removal of encroachment in compliance with the order of the High Court, Calcutta. Now, lordship kindly see the next bottom, dated 17 January 23. They fixed for hearing on 31st January. They submitted report not on 17 January. But that is why, Lord, I came. Your lordship, not only thing I will show your lordship one judgment. Your lordship kindly see this is the apex court judgment, paragraph 20, paragraph 31. Your lordship. Anyhow, Lord, your lordship's order they should be complied with. Your lordship kindly see.
Prayer is identical.
Yes.
The contempt
Well,
application.
they will continue the process.
Contempt application.
Faith, Lord, your lordships, they submitted this report and unfortunately we have not seen your lordship disposed of the contempt application. My submission is they should process this same thing. Your lordship kindly see paragraph, but last paragraph, your lordship 32, I think, Lord, that is it. Anyhow, Lord, your lordship's order, they should be complied with. It is the order, Lord, several order is submitted by the Supreme Court.
Is judgment delay?
And they submitted the report on 31st. On the other hand, they fixed the matter on, they submitted report on 17 January and they fixed the matter on 31st January for hearing.
Yes, 31st January.
Yes, almost then they have not complied, they have not completed their process. Your lordship kindly see the report.
The direction was for disposing of the representation.
Yes, the lordship kindly, yes, your lordship kindly see page 25, para 12.
Yes.
What is their compliance? From the aforesaid happenings, this is to conclude that whole process of removal is in motion. Now, paragraph 11, they fixed the matter on 31st January and they submitted report on 17 January. Hearing fixed on 31st. they submitted report for compliance on 17th January.
Yes, so what is the difficulty?
Grievance, they have not complied with, but they have submitted
What
report.
was the compliance asked for?
Asked for,
Compliance was
they
disposed of
have to
representation.
removal.
No.
What was the earlier order? It was disposed.
Earlier order, yeah, Lordship kindly see,
Not removal.
yeah, Lordship kindly see page 17.
Yes.
Yes.
Dispose of the representation. That has been disposed of and proceeding has been initiated.
Proceedings has been initiated, but they have not completed. They have not completed. Proceeding has been initiated because Lordship kindly see the
What
their
is the
order.
state? Let us hear the state. What is
My
the
lord,
state of the?
actually, this is the my lord, whatever documents the annex my lord, it is on contempt proceeding, my lord. Lordship's direction was that my lord to dispose of the representation and pass a reason order. Most probably that was the pass a reason order. And that reason order was not passed. He has filed a my lord contempt application.
That has been disposed of.
Contempt application not disposed of, my lord. No. Contempt application pending, my lord. Contempt pending. No, my lord. Kindly come to paragraph, my lord.
Contempt disposed of. Your Lordship kindly see page 29. That is
Page
the
29?
yes.
Yes, it is
Just a minute,
disposed of.
just a minute, but my lord, I am just.
It was
Page
disposed
29.
of. Yes, it was disposed of, but wrongly. They have, your Lordship kindly see page. Your Lordship kindly see page 26. They have initiated proceedings. Your Lordship kindly see page 26.
Removal in motion, my contempt not my lord, disposed of. Contempt application
Page
not
29.
page 29. Just a minute.
Disposed of.
Yes.
Yes. Your Lordship kindly see page 26. This is the proceeding initiated, but they have not complete the, yes, that is my grievance.
Then my lord, lordship's kindly
Let them proceed.
according to my lord, section 10(1) proceed.
Yes.
Either my lord, lordship can direct the my lord
Order says that
to comply the
10-3
order of the report, comply the report of the
10-3 has been issued.
issued.
10-3 hearing notice has been issued.
Issued.
So complete the proceeding.
Yes.
Within 1 month.
Yes.
Affidavit of service.
Yeah, we can.
Paragraph service upon the private respondent has returned with an endorsement. within bracket
Judgment को service
from
matter
court and
judgment देखना चाहिए that has to go.
accused, which amounts to
No,
good service.
No, he
Paragraph
judgment
none
on the
appears for the private
service
respondent
law.
despite service. Paragraph. Pursuant to an order passed by this court in an earlier writ petition, pursuant to an order passed by this court on 2nd December 2021, in an earlier writ petition being WPA 24452 of 2018, comma, proceeding under section 10 of the West Bengal Highways Act 1964 was initiated by the concerned authority and notice was served upon all concerned for hearing under section 10(3) of the Act of 1964. Stop. The petitioners pray for a direction upon the respondents, the state respondents, conclude the said proceedings within a stipulated time frame. Paragraph upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that since proceeding under section 10 of the West Bengal Highways Act 1964 has been initiated and notice of hearing under section 10(3) of the Act has been issued, comma, the concerned authority, the eighth respondent, the subdivisional officer is the third.
Yes.
The eighth respondent herein, comma, be directed to conclude the proceedings within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners and the private respondent, comma, in accordance with law. Paragraph. With the above directions, the petition is disposed of.
Grateful to your lordship.
Disposed.
Start it.
Yes.
My lord, appearing behalf of the.
Lord, I beg to appear on behalf of the state respondents.
Affidavit of service effected upon all.
That he alleges, my lord, encroachment.
Private respondents are, you are appearing, who is appearing for the private respondents?
Affected upon all, my lord, including private respondent. The private respondent number 7 and 8, by occupying the public land, the store wood and my ingress and egress entirely, my lord, stopped, my lord. This is the allegation. Wood and clattered object. My lord, page 32, representation. Page 32. Representation.
Yes.
My lord, in terms of his representation, my lord, we have conducted an inquiry. Lots have been identified and demarcated by the BLR. My lord, there is no encroachment.
There is no encroachment.
Yes, your lordship kindly takes, my lord, my written instruction.
But after writ petition, they removed that encroachment.
On 10th,
Maybe.
nothing remains in the writ petition. See, your lordship kindly records my instruction.
Send to the SDO respondent number 3 for
On
consideration.
10th, my lord, May, my lord, this is the report, my lord, 10th May 2023, there is no encroachment. And BLR report is also there, my lord.
So nothing further remains.
Nothing remains, my lord.
Affidavit of service. None appears for the private respondents, despite service. Our article statement of facts submitted on behalf of the state respondents is taken on record. Paragraph. The petitioners allege illegal encroachment upon government land adjoining their property, comma, thereby obstructing their egress and ingress. So the petitioners submitted a representation in this regard before the concerned authority on 14th January 2018. Stop. Paragraph. It is submitted on behalf of the state respondents that pursuant to the representation made by the petitioners before the authority, comma, the Block Land and Land Reforms Officer, Mohishadol, Purbo Medicine. Held an inquiry into the matter and identified the government land adjacent to the plot of the petitioners. Stop. The report says that there is no encroachment in front of plot number 114 belonging to the petitioners. Paragraph: in view of the above, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of. Paragraph: they should have no rest cause.
Extremely grateful.
Lordship. 29 Lordship, we have the petitioner praying for not today only.
Not today means after vacation. On prayer of the petitioner, the matter is adjourned, let the matter appear under the same heading on 19th June. 19th June.
30.
My lord, I am for the petition.
State,
No, I am for the private respondent.
who is appearing for the state?
Blood, we beg to appear on this.
30? Yes. Yes.
My lord, the case of the petitioner is that, my lord, the private respondents have been running one business of a furniture store. My lord, on a plot of land in question. My lord, in the due course of running the business, my lord, the private respondents have encroached over a substantial portion of the Pakka footpath and the road belonging to the PWD. We have made, my lord, several representations to the concerned authorities, but my lord, no steps have been taken. My lord. So, my lord, I am praying that, my lord, the representation of the petitioner may be considered, and my lord, steps may be taken to hold, my lord, page 28 of the writ. My lord, page 28 of the writ petition. 26, sir. 28. Last.
My lord,
Yes.
what happened, my lord? In this particular this land, my lord, already my lord passed an order. In view of the my lord's order, proceeding was initiated. My lord, kindly see the your lordship's order as well as the my lord, notice issued to me. This is the order, my lord. Same land, my lord. Several hearing was conducted lastly on February, my lord. Same. দিন না নাম লিখে দেবো চলছে ওই যে দিলাম আছে দিচ্ছি আপনি কি বলবেন আপনার তো হলেও কি না হলেও দিচ্ছি দাদা কপি দিয়ে কি হবে দাঁড়ান
This was also by the same writ petitioner.
yes several entire land entire road
This by Vaibhav Arora. He was not a petitioner in the earlier writ petition.
no and but same land several private party are involved, my lord.
This is Kharagpur, my lord. আরে অর্ডারে আছে দিন নাম দিন 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 আরে বাবা
How do you say that it is the same land?
my lord kindly land schedule.
This is SBI E corner to
No, my lord, look, the third page, my lord, kindly.
third page of the writ petition.
No, my lord, I have handed over the document, my lord. জেল নাম্বার কত আছে 232 my lord kindly see the land schedule my lord this my lord jail number kindly see the jail number 232 in the my lord
Yes, yes. Going on.
My lord, if the proceedings have been initiated, my lord, kindly direct the authorities to conclude the proceedings.
my lord already order is there my lord
Identical issue.
yes
How will the second petition lie? You take instructions and come back.
Can I take instructions, my lord?
Let him take instructions because it's the same.
Whether it would be withdrawn or not.
Yes,
Whether it would be withdrawn or not.
it will not lie in that case. Proceeding is on.
In respect of the same petition or
no পিটিশনার আলাদা কিন্তু রোডটা তো তুলছে রোডটা খড়গপুর রোডটা ওটি রোড
Same road by the.
Yes.
Pursuant to an earlier writ petition, section 10 proceeding has been
10 and
initiated.
2.
yes
2 and 3.
yes
And you have made an identical prayer in this writ petition also. So please take instructions and come. Service. Paragraph it is pointed out by learned counsel for the private respondents that the prayers in the present writ petition are identical to that of an earlier writ petition being WPA 7914 of 2020 and the plot as well as subject matter of both the writ petitions are also identical. Stop. Pursuant to the earlier writ petition, comma, proceeding under section 10 of the West Bengal Highways Act 1964 has been initiated. Stop. Paragraph in view of the same, the learned same comma third category, learned counsel for the petitioner third category seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 8th June.
My lord, kindly fix this before vacation, my lord.
You have no urgency. Come back on 8th June.
Okay.
okay বলুন
The proceeding is already going on.
Okay.
That serves your purpose.
Very good.
শর্টকাটে করার
153.
My lord, I'm for the petition and Mr. Sen is supposed to give a report on the form of affidavit.
1.63.
Oh, I see. বলেছি, মামলাটা ওখানে আমি ready হই। Well, this is the issue of wrong endorsement by the RTO Barashat in respect of a hire purchase vehicle of the financer. He was misled by forged document.
Initial stage. And at that time, our seniors told me that if we do not reach, then kindly get warm up. That means start the matter.
Yes. This is a very short issue.
My lord, now may I tell you, see, my lord, since 2008, 2009 matter, it is the, my lord, the contention of the petitioner is that they are the financier of a particular vehicle. Now that vehicle, my lord, when it was under hypothecation agreement, subject matter of the hypothecation agreement, then the hirer, who the registered owner of the vehicle, but the hirer cannot transfer the vehicle in favor of any other person without their no objection certificate. And that is the law also under the Motor Vehicles Act. According to them, that vehicle, the hirer being the bailee, who being the registered owner, he transferred the vehicle in favor of other person. Now, third party right has been approved, but without their knowledge. Now they say that at this petition filed in my lord 2010. Now, my lord, today.
You have filed a report.
My lord, not yet, my lord, may I take? If your lordship kindly have a look this, my lord. Nothing is on record except, my lord, whatever it appears from the, my lord, the computer data. That it appears computer data because at that time manual, nothing is available. As per Pahon database, vehicle was registered in 2008 March with hypothecation. That is the first time. But the name of the agency is not visible as because it was done in manual system then. No such old record is found in this office. The hypothecation was terminated on 3rd February 2009, which according to them not the receipt number by which the fees was taken to terminate the hypothecation is such and such appears from, my lord, the computer system. Vehicle was transferred in favor of the other person on 27th February 2009 from Kamul Khan to Soma Mujumdar via application number such and such and fees receipt number such and such. Then the vehicle blacklisted in 2009 November on the basis of the complaint filed by the read petitioner being the finance. These are the only available records. If your lordship, my lord, direct me, my lord, only thing I can, my lord, all these things can be, my lord, it is written down in the affidavit, my lord, because no further, my lord, nothing is available. My lord,
Thank you. Now, the issue remains, I appreciate what my letter senior friend said. Our vehicle has been blacklisted pursuant to my complaint. No purpose served. In the meantime, I obtain an award. So I can't deal with the asset until that impugned registration is cancelled, reversed. So that on the basis of the documents, lordship can direct the RTO Barashat to.
Registration is the name of Shoma Majumdar.
Yes, that is the impugned.
Registration.
My borrower is Kamal Khan.
Registration.
He suppressing, produce some fake document as no objection.
Without their no objection.
Absolutely.
According to them. Now, our record shows that at least no objection certificate
that is forged. Exactly.
And the cancellation of hypothecation agreement is deposited. Our record shows.
Our case
now,
is. Sorry.
Now, my lord, the whole issues remain with that. First of all, my lord, it is to be declared that the subsequent registration in the name of Shoma Majumdar is, my lord, contrary to the provisions of the law, and that is to be set aside first.
Yes.
Then, my lord, otherwise, my lord, we do not know whatever the award he obtained from the
that's different part. That is practical. As Mr. Sen suggested,
is not appearing. So I cannot, my lord, take the brief on behalf of Shoma Majumdar. I only say whatever my record shows.
Have you served 4 and 5?
Yes, earlier I have served.
Earlier.
Another set, let me
Let him
some.
serve once
Yes,
more
yes,
and
yes,
come back.
yes, yes.
Because
Shoma Majumdar filed affidavit in opposition, but your lordship didn't find it on record. Served us, we filed our reply.
the reply is on.
And there was a counter writ petition by Shoma Majumdar, which was dismissed by your lordship for default. I appeared for the financer.
Why don't you serve once more and come back?
He is very old.
Waiting for very
A very old matter. Both of them. Both of them,
4 and 5 both.
only 4 and 5.
Yes, yes. So he's appearing for that.
And my lord, on the next day, my lord, I think, my lord, pursuant to my lord's earlier order, I shall comply with that by filing a report, at least on the basis of this, whatever is available.
That is the compliance. And on the next day, if they are not appearing, I'll pray for allow my prayer by saying yes.
Do not adhere despite service. I think.
My lord, my lord, my lord.
But it should be served.
My lord. আমি খুব দায় পড়ে করতে হচ্ছে এটা পুরোটা মামলা স্টেটেড না আমি তো দায় পড়ে এটা করছি
Instructions submitted on behalf of the state respondents. Taken on record. Paragraph, since the matter is pending for long.
4 and 5.
The petitioner is directed to serve the 4th and 5th respondents afresh and file affidavit of service on the urgent date. None appears for the 4th and 5th respondents. Paragraph, let the matter appear under the same heading. On 12 June.
12 June.
And my lord, time to file the report, either
That
be
means-
extended or my lord.
Yes.
Character line for
Formally.
By that date.
none appears, instruction for it. Learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as intended.
In terms of earlier order.
That is the.
Get.
12 June. আমি সার্ভিসটা করে এভারেজ সার্ভিস পাই
Get.
154.
This is a case where the route permit of the petitioner granted to the petitioner was subsequently cancelled in a meeting, not for any fault on the part of the petitioner. It was the specific observation at the meeting that the then Secretary of the Regional Transport Authority, he failed or neglected to perform some procedural steps. And that is why my permit was held to be not in proper form and cancelled. Subsequently, I made a prayer for granting the permit because no fault on my part is recorded. They have accepted the renewal fee from me also. But my application is annexed to this writ application at page P22, annexure P4. In July 2019, I made it. It is still pending
Where is your representation?
at page 22, annexure P4. And kindly come to page 24. They have accepted the renewal fee also from me.
Yes. Yes, Mr. Debra.
It appears from the review order that the Secretary at RTA himself issued the permit. Also, he has no power. That is why RTO board also rejected the permit. So he has also, it appears from the record matter, he has also made a prayer and also deposited certain fees for renewal of permit. Let it be considered by the RTA Malda.
The petitioner claims to be the registered owner of the vehicle in question and route permit and was flying the vehicle by virtue of route permit granted to him. So, the petitioner deposited prescribed fees for renewal of the permit. Stop. By an order agenda number 24, this is a meeting, board meeting.
Yes, item number 24 is a board meeting. The order date is 14 December 2008.
By a decision taken by the RTA board in its meeting held on 26 November 2018, the permit granted to the petitioner was cancelled for violation of the provisions of the Motor Vehicles Act 1988. So, paragraph, it is submitted on behalf of the petitioner that the permit was cancelled due to no fault on the part of the petitioner. Paragraph, learned counsel for the state respondents also submits that since the permit was issued by the secretary Regional Transport Authority.
Regional Transport Authority, Malda.
Regional Transport Authority, Malda, who had no authority to issue the same, the same was, this is the submission of the state, the same was cancelled. The petition paragraph, the petitioner submitted a representation before the concerned authority on 8 July 2019 for issuance of permit for the route Malda to Raigad, which is yet to be considered by the authority. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the who should consider?
The board is to consider.
One difficulty arises, that the permit has already been cancelled. So first, it has to be restored by the RTA board, otherwise not. Then question of renewal or something like that.
The RTA board is not a party.
Yes, Regional Transport Authority.
The RTA board to consider his prayer.
Yes.
That will be better.
RTA board is
Respondent number 2, Regional Transport Authority.
the Regional Transport Authority.
Mile.
Then the second respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of directly the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month. Within 1 month from the date.
Only petitioner is there.
Yes, within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
But 55.
Like quite few occasions, this matter was taken up for hearing by your lordships. State was directed to submit report in the form of affidavit. I have also, Mr. Sen is appearing.
Mr. Sen is appearing.
Report was submitted, but I also use my exception to the report. All have been filed before your lordship. My case, if your lordship recollect, my case is that on 24th of May 2020, I own a commercial vehicle. When the vehicle was flying in the first morning, my vehicle was intercepted by the respondent number 4, Regional Transport Officer, my lord, Diamond Harbour. He intercepted my vehicle. He demanded certain bribe from a driver. A driver was flying the vehicle, which he denied. Thereafter, the original documents lying in the custody of the driver, everything have been snatched. Money was extorted. His money bag was taken. Thereafter, my lord, a challan was given on 4 heads, imposing penalty of 42,000. Then on the following day, the husband of the petitioner went there. Thereafter, my lord, I made representation before the authority and made a complaint. Driver made a complaint before the local police station against the erring officer. Nothing was done. Then, my lord, I moved this writ application. While admitting the writ application, my lord was pleased to direct my learned friend to use the report in the form of affidavit. The report is nothing but denial of the contention made by in the petition. This is oath versus oath, my lord. I have also used my exception. Now I will invite your lordship to come to the report. Kindly come to the report.
Yes.
His stand, he has narrated from paragraph 5, page 4.
Yes.
May I read? On 24th of May 2022, as a part of my said official duties, I intercepted the said vehicle number so and so on Raidigi Road, since the said vehicle was moving dangerously with a high speed. Here I pause, my lord. He is saying that my vehicle was moving dangerously with a high speed. How he determined the speed, nothing has been explained. Where is the speedometer? How he came to a finding? Nothing has been explained in this paragraph. The person who was in possession of said vehicle, that is driver of the vehicle, was asked to produce the original registration certificate, book of the said vehicle to ascertain the validity of fitness certificate, original permit endorsing the said vehicle, permitting to carry goods as commercial vehicle, original documents pertaining to due payments of road tax and additional tax payable for the said vehicle, and insurance certificate. These documents were allegedly demanded by the said authority. The driver of the said vehicle named Gopal Pal could not and or failed to produce any of those original documents on that day and admitted that neither he did possess nor in the said vehicle there was any such original document as required to show. Next, paragraph 7. Next page. However, the said driver of the vehicle in question on 24th May 2022 handed over me the photocopy of the road tax receipt dated 29th April 2021, recording payment of road tax and additional road tax up to the period of 7th April 2022, photocopy of certificate of insurance recording validity period of said insurance from 21st January 2021 to 20th January 2022, photocopy of certificate of fitness of the said vehicle showing validity period of that document up to so and so date, and photocopy of party of the permit attached to the said vehicle, incorporating the particulars of the load capacity and gross vehicle weight of said vehicle as 5500 kg and 8250 kg respectively. Here, once again, I pause one. He is admitting the photocopy of the documents were handed over to him. So he is under compulsion, my lord, to give a seizure list. If he takes the photocopy, obviously he is under compulsion to give a seizure list to my driver. They have not annexed. They have only annexed the documents. So the hiring officer is telling lie before your lordship. On oath, he is telling lie. Next paragraph. The deponent reasonably believed that the said vehicle was overloaded and accordingly asked the driver of the said vehicle to move the same towards the nearest way bridge on that day itself. The driver of the said vehicle did so. The weighman was done in his presence, and the certificate issued by the concerned weigh bridge against the said vehicle being dated so and so, after weighing the vehicle with loaded goods, recorded the goods vehicle weight as rupees 11,250 kg. Now he is saying the weight was taken in my presence. Where is the document to prove that my driver was present there? I'm asking this question to myself. Nothing has been annexed, nothing has been stated in the affidavit. Then, my lord, the next paragraph, paragraph 9, is on 4 heads, the fine was charged. Number 1, towards middle, rupees 10,000 fine, penalty for without permit. I have the permit. I had the original. So question of without, I have annexed my Xerox copy of the permit in my writ petition. I had the original permit. Rupees 26,000 fine penalty for carrying excess load. I do not know how the weight was taken by assessed by the respondent number 4. Rupees 500 as compounding fine for non-payment of tax. Up to date tax receipt was there. I have annexed that document in my writ petition. Rupees 5,000 towards fine penalty for driving dangerously. I do not know how they came to a finding that I was running the vehicle in dangerous way. This is the head. Now, my lord, kindly come to the most important paragraph, paragraph 11. Next page. Page 11. On the next date, that is on 25th of May 2022, the husband of the petitioner came to the office of ARTO Diamond Harbour and handed over the original RC book, original permit A part. Once again, I am reiterating, my lord. What occasion arose to the husband of the petitioner to go to the office and to hand over the original? If for the sake of argument, it is taken to be true that my husband went to the office and handed over the original, then again, the authority was under compulsion to issue the seizure list. In simplicity, they cannot take away the original papers. Where is that seizure list? Nothing is there. So it can be presumed that they have the originals with them. That is why these statements have been deliberately made by the concerned officer. So this is my submission, and I have stated all these things in my exception to the report. All the originals are lying with the officer. This is nothing but an extortion. My vehicle was intercepted in the first morning. Money was demanded. As he failed to give the money, as he failed to satisfy the officer, the original documents were snatched away by the hiring officer. All are lying in the custody of respondent number 4. And by this way, this bill has been slapped upon me.
According to them, the RC book and the original permit A part is like.
Yes. My husband went there, handed over the original of the RC book and the permit A. If those documents were at all handed over, then is it not the duty of the officer to issue seizure list? I'm asking this question to myself. Yes. How they will take the originals without giving any receipt? If it was there, then they could have annexed with this affidavit. Nothing is there.
Before taking that, my lord, report in the form of affidavit. Now, my lord, my first contention is that my lord, since the matter relates to my lord the seizure of the vehicle for non-payment of road tax and additional tax. Now, my lord, when vehicle intercepted on the ground of non-payment of tax, road tax and additional tax. Now, my lord knows that there is a provision under the Act that if any steps is taken by the authority concerned, here the motor vehicle inspector, and any penal action is taken, that is, my lord, slapping of any, my lord, the fine or other thing, then, my lord, there is a provision for appeal. A statutory appeal provision is there in both the statute, in the 79 Act, as well as, my lord, the Additional Tax Act. Now, my lord, I have shown before your lordship on other occasion also. Now, my lord, this is not a maiden matter, my lord. Sometimes this type of, my lord, matter, my lord, come up because that the aggrieved person, he may come before the honorable court, challenging the said seizure of the vehicle or seizure of the document. Now, my lord, in one such matter, my lord, the writ court, my lord, refused to entertain on the ground that there is an alternative remedy, statutory remedy. Now, my lord, the being dissatisfied with the said order of the coordinate bench, now, my lord, the petitioner therein, my lord, prepared an appeal before an intra-court appeal. Now, my lord, I do not, my lord, right now, my lord, recollect that whether the order already handed over, but this is the order of the division bench. If your lordship kindly have a look, order of the division bench 21st June 2022.
It's
Now, my lord, if your lordship kindly, my lord, they are also almost, my lord, the issue was that whether that seizure was lawfully done or not. Now, the third paragraph, it appears that it alleged violation of Motor Vehicles Act 88 relating to non-payment of taxes, flying of pass without permit, and so on. Undoubtedly, any remedy arising out of any wrongful tax demand by the respondent authority is under Section 9 of the Tax Act. All the allegations in the impugned notice have not been taken care of by the said provision, especially the one relating to flying the bus without permit. He submitted. It was submission. Now, advocate for the respondent rightly points out that if the allegation of flying the bus without permit is proved against the appellant, he will be liable to pay 17 tax. But this is the other issue. In those circumstances, we are of the view that the writ application was very rightly not entertained by the trial court, relegated to the alternative remedy under Section 9 of the said Tax Act. We dispose of this appeal affirming the order of the learned trial judge. We also make it clear that all questions of fact relating to payment of tax, possession of permit, etc., shall be decided. Lordship, kindly, possession of permit, etc., tax payment shall be decided by the respondent authority under Section 9. If and when it is approached, the respondent authority, when moved, would dispose of the matter as early as possible by recent order after hearing the parties. We add that if the appellant petitioner approaches the said respondent authority within 4 weeks from date, any prosecution of the appellant contemplated by respondent authority under Section 192A of the MB Act could be commenced only after proper finding of facts. Now, my first submission before your lordship is that after all, the matter, my lord, relates to the, my lord, the non-payment of tax first. And if it appears that for the period on 24th May, when the vehicle was seized, my lord, that the vehicle, whoever in possession of the vehicle, he did not possess the, my lord, the requisite, I mean the receipt showing payment of tax, whether he is a driver or he is the owner of the vehicle, then, my lord, automatically, my lord, the penal provision runs automatic and the vehicle was seized. Now he says that no, the permit was there, the tax already paid.
That is your admission also.
No, I have nothing. I have
Paragraph 7.
no, my lord, no. I think, my lord, if your lordship, yes, paragraph 7. Paragraph 7. the driver of the vehicle in question, because the, my lord, the incident, my lord, happened on 24th May. Driver of the vehicle in question on 24th May 2022 handed over photocopy of road tax receipt dated 29th April 2021, recording, my lord, tax receipt. Very good, my lord, not original, what I admitted. Photocopy of road tax receipt dated 29th April 2021. And this is, my lord, of 2022, recording payment of road tax and additional road tax up to the period 7th April 2022. And the vehicle seized on 24th May 2022. Then photocopy of certificate of insurance, recording validity period of insurance from 21st January 2021 to 21st January 2022. All for the earlier period. Those periods expired. So these have no, my lord, these were not valid on that point of time, even if those are, my lord, the photocopy. Now, next, photocopy of certificate fitness of the said vehicle, validity period of that document up to 27 January 2021. And for photocopy of part A of the permit attached to the said vehicle, incorporating the particulars of load capacity and gross vehicle weight. These documents, my lord, the driver produced on 24th May.
Where is the seizure list?
Seizure list, my lord, may I tell? Well, I have, my lord, explained that since those are the photocopies, so there was no question of seizure list. My lord, this next, Lordship, kindly come to page, my lord, paragraph 8. Because those are not at all document, all those expired document photocopy of those documents.
They were taken by the authority, by the NBI.
I'm coming to Lordship. Kindly, my lord. Next. 8. The deponent reasonably believed that the said vehicle was overloaded and accordingly asked the driver of the, my lord, driver is not before your lordship, driver has not yet, my lord, come up and affirm anything, my lord, now, because petitioner was not there also. Accordingly asked the driver of the said vehicle to move the same towards the nearest weighbridge on that day itself. Driver of the vehicle did so, the weighment was done in his presence. And the certificate issued by the concerned weighbridge against the said vehicle being dated 24th May 2022, after weighing the vehicle with loaded goods, recorded the gross vehicle weight 11250 kg. Pertinent to state that the said vehicle was intercepted at about 6 AM in the morning, which fact is admitted by the petitioner at paragraph number 8 of the writ petition. And as per the weighbridge certificate, it was brought to the said weighbridge almost immediately, be that as it may, said vehicle was overloaded by 3000 kg. And the, my lord, the weighment certificate annexed. B. Annexed B, my lord. This is the weighment certificate. And my lord, the dated 24th of May 2022, in the middle portion, right hand side, my lord, to some extent, my lord, non-visible, but my lord, visible to that extent that 6.05 time. Immediately. Now, then, my lord, the breakup of the fine. Then, lordship, in needless to mention, at the middle portion, needless to mention, immediately on that day, 24th May 2022, copy of the challan was duly handed over to the driver of the said vehicle, who, as a mark of acknowledgement of the receipt of that challan, put his signature on the said challan on the same day. Annexure C. Annexure C, my lord, that is page number 16. Page number 16 is, my lord, that immediately, my lord, that challan prepared and showing the amount with breakup which are to be paid, and at the bottom, my lord, signature is there, Gopal Pal, driver. And Gopal Pal driver, this name also appears in the writ petition also. They said my driver name is this. On the same day, immediately. And the driver received it. He says driver received this. And at this Women Bridge site, driver was not there. It is also not believable because who drove the vehicle? Now, paragraph number 10, my lord, kindly come to. Rest of the paragraph, my lord, I want to place before your lordship, my lord, paragraph number 10. The deponent submits that since the person in possession of the said vehicle failed to produce or hand over any original document pertaining to the said vehicle, there was no question of recording seizure of photocopies of those documents on that day, namely photocopy of Part 1 permit, photocopy of insurance certificate, photocopy of road tax receipt of the period from such and such. However, all those papers being photocopies of documents pertaining to said vehicle are annexed here too. Of those documents, because unless it handed over to me, my lord, it is not possible for me to annex these documents here. I have annexed here. These are all invalid documents, my lord. So there was, my lord, the officer thought that, so because seizure of the valid documents, seizure of those invalid documents, he produced, I have seen, very good. Now, Kaushik, kindly come to 11 on the next day.
But in no case have you issued a seizure list.
No, chalan, only chalan. These are the fine. That I have to admit. Then lordship kindly come to 11, my lord. On the next day, on 25th May 2022, I shall corroborate this. I shall corroborate this with the document they produced and I have annexed it. They have not denied. No, it is not the document. On the next day, that is on 25th May 2022, the husband of the petitioner came to the office of ARTO Diamond Harbour and handed over the original RC book, original permit. I have not said that I seized the document. In fact, handed over to show that this is the document which my driver could not show you on the earlier day. There is no question of seizure any further. So no seizure. No seizure. Now, lordship, kindly see 25th May. Why I said this? 25th May, lordship, kindly come to my lord. Now, Annexure D.
These explanations are required. You take the original document is made over to you. You just take the document without any issuing any document.
Original documents never cease, lordship. Original.
Handed over to you.
My lord.
Handover means.
Original document, my lord, original document they showed on the next day, original document never seen. What I do with the original document? Lordship, kindly consider one thing. He can go before the RTA office and he can always have the copy of the document from the, my lord, lordship, kindly consider one thing. I have no business to retain the same original document. On the next day, 25th, what happened, lordship, kindly come to page number 17. Page number 17, my lord, kindly come.
17.
Page number 17. He said that, no, my husband has not gone there. Immediately, my lord said that her husband has not gone there. Now, page 17, lordship, kindly see Annexure D.
Page 17, 17.
Annexure D, my lord, possibly the last annexure of the report.
Yes.
Have a lordship seen, my lord, the last annexure? My lord, this is the, my lord, a statement wherefrom it appears that the tax of that particular vehicle, when it was submitted, and my lord, the first column, the first line, the receipt number, then tax from 8 April 2022 to 7 July 2022. 8 April 2022 to 7 July 2022. Within this period, that particular day, my lord, falls, that is, my lord, 24th of May, when the vehicle was seized. So tax paid for 8 April 2022 to 7 July 2022, when, my lord, kindly come to, my lord, the date, Chalan date, 25th May 2022. So on the next day, my lord, the tax paid for that period, and then my lord came and so that this is the tax I have paid. So whatever the seizure that was done on the earlier day on the ground of non-payment of tax, that is, my lord, it appears that is correct. On 24th of May, the requisite tax for that period was not paid. He paid on the next day. That does not mean that whatever the offense already committed, Lordship, kindly consider one thing. The offense already committed, that can be diluted. That cannot be. Now, my lord, as per the law, my lord, as per the tax act, if it appears that a tax for a specific period, my lord, I think, my lord, section 12 of the 79 Act.
Yes. Yes, the permit is rendered.
Permits to be invalid in case of non-payment of tax. Notwithstanding anything contained in the Motor Vehicles Act 88, non-obstante clause, it starts. If the tax due in respect of a transport vehicle is not paid within the period determined by taxing officer under subsection such and such, the permit shall be invalid from the date of expiry of the period determined by taxing officer under subsection 1 of section 4. That means that subsection 1 of section 4 says that tax is to be paid. The failure to, my lord, comply with the said provision, that means, my lord, non-obstante clause, that despite being the fact that you possess the valid permit, that permit should be taken as if no permit.
Yes, yes.
And it's a, my lord, it's a case of, my lord, note that operation of statute. Immediately, operation of statute. So, my lord, so now he says that permit is there. But the thing is this, that you may have permit, but because of operation of provision of the statute, it should be treated as there was no permit. Because tax you deposited on the next day. And that is why, my lord, all these penalties, my lord, charges. Now, my lord, my lord, beseech your lordship that no original papers, my lord, he has shown on the next day, but no original paper has been seized. Nothing is with the, my lord, the person concerned, the officer concerned, and there is no question of keeping some paper.
But you say handed over. Handed over means taken.
My lord,
Produced.
my lord, maybe
Paragraph 11.
my lord, the expression maybe that handed over means that handed over.
Yes.
But the thing is this, my lord, he can come and on oath he can say that it has not been seized.
This is on oath.
No, I say this, my lord, I say. The fact, I cannot develop in other way. What is the fact that I can say before your lordship? Now the question is, my lord, that next, my lord, the remaining allegation regarding, my lord, the wanted, the bribe and other thing, the snatching away bag. These are all, my lord, he said, and these are all denied. All those, my lord, the allegations are denied. Now I leave it to your lordship, my lord, that whether, my lord, this prayer with regard to, my lord, that prayer A, my lord, return all the papers in original in support of the said vehicle. Cancellation of imposition of tax. These are the main prayer.
With regard to the original RC book and original permit A part, there has to be an order for return. Because it is admitted.
He has to, but my lord, I can file a supplementary affidavit if your lordship, my lord, asks me. He will say that nothing is with him because, my lord, nothing has been seized, nothing is with him. So kindly consider one thing. Because
can you contradict your admission?
Yes.
By way of a supplementary affidavit? This is your admission.
My lord, it is true that it is written therein as handed over. I do not deny this.
Yes.
I do not deny this.
You cannot develop this by way of a supplementary affidavit.
No, I am not on that. I can say that it can be explained, lordship, kindly. I leave it to your lordship. But the thing is this, the paper which is not with him, my lord, he will never be, my lord, in a position to return the same, lordship. Kindly consider. What he will do with this thing? Lordship, kindly, he only, my lord, he is, my lord, only, my lord, with
He can do is an unanswered question, Mrs. We do not want to go and get into that because the allegation is serious. What he
no,
can-
other allegations, my lord, oath versus oath, with regarding that, my lord, the demanded bribe and other thing, that he, my lord, I think, he cannot prove this in this way. In this way, my lord, one cannot prove that this after seizure of the vehicle, that the MBI technical wanted bribe.
In fact, the
If that is so, then my lord, kindly consider one thing, that of the offense committed or not. Offense committed.
the report cannot deal with that at all.
Yes, offense committed, because on that day, my lord, the tax was not paid. He was defaulter or failure to make payment on the next day. Kindly consider one thing. So whatever, my lord, steps he has taken with regard to, my lord, the interception of the vehicle, because vehicle has not been seized. It is not his case that the vehicle, my lord, may I tell, if anything in his mind otherwise, may I tell one thing, he could have seized the vehicle, because he had every right to retain the vehicle also. In the present case, my lord, vehicle has not been seized. For non-payment of tax, he has every authority to seize the vehicle. Vehicle has not been seized.
Where is the document showing excess load?
My lord, that is the certificate of, my lord, I have annexed to my report.
Page 15 in his report.
Page 15, annexure B. The women certificate, it shows 11,250. And my lord,
And what is the permissible limit?
permissible limit is, my lord, whatever is, it appears from the, my lord, the registration certificate book, that is, my lord, it appears. My lord, kindly come to paragraph 7 and paragraph 8. At paragraph 7 in the report,
Yes.
at paragraph 7 in the report, within Roman 4, photocopy of part A of the permit attached to the said vehicle, incorporating the particulars of load capacity and gross vehicle weight of the said vehicle, 5,500 kg load capacity, and gross vehicle 8,250 kg gross vehicle weight, GBW 8250. And after women, it appears
11,000.
11,250. So for overweight, that is, my lord,
What is the mode of calculation?
$26,000 fine for penalty.
In all the 4 charges,
My lord.
what is the mode of calculation of penalty?
Yes, mode of calculation, my lord, time to time, my lord, as per the circular or notification, time to time, my lord, I have one, my lord, my lord, I'm showing that particular provision, my lord. My lord, there is a chart, my lord, that against each and every, my lord, violation,
There should be some basis on which.
Always, 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 always.
If you
my
come back with a supplementary affidavit.
My lord, please, please, my lord,
all the details.
I can annex that particular chart.
That circular plus, the Caesar list part, the Caesar. Let him come back with the supplementary.
Kindly restrict so far paragraph number 11 is concerned. Already my lord has held that. He cannot improve that paragraph.
My lord, improve or not, my lord, may I come? I leave it to your lordship.
They are already there on record.
Yes.
On record, on oath, he has stated.
Yes, yes,
Let him come back. I am acting primarily on the calculation.
yes, yes. My lord, I shall come, my lord, because
Your-
one seat of calculation
One
with
head.
me.
You had defaulted in your.
On head. That is tax failure. Only 500 rupees fine. So for other heads, my lord, he has stated in my presence payment was taken. Where is the document to prove that I was present? Where
No,
is
no,
my
he was
signature?
not there. His driver was
My
there.
driver. I'm saying to my driver.
Let him come
Yes,
and
yes,
say,
my
let him-
driver. Where is the document in the
The
OMN?
document, my lord, if he does not sign, what can be done?
Have you stated? Have you stated
This is not
that?
the suit
Have
code.
you
Lordship, kindly
stated?
consider one thing. This
Your
is,
affidavit,
this
you
is
have
not the
stated,
suit code.
my
That each
driver
and
in my-
every matter is to be, my lord, in this way, my lord.
Have you
Placed
stated the
before your
driver
lordship.
refused to put his signature? Nothing is there.
Please come back with the
Yes.
supplementary.
First thing is that whether he made a false statement that everything paid, everything paid, everything paid. If that, whether that is a false statement or not. A person who has come up before the writ court, he should come in a clean hand. First thing is this. Officer may, my lord, they may, my lord, in course of duty, there may be some sort of fault or not there regarding that seizure of that, my lord, the xerox copies of documents, and that too, which is not valid at all on that day, photocopy of. It has not been denied that no, we did not produce those photocopy of expired, which were not valid at all. And whether his driver was there or not, how can he say on oath that yes, my driver was not there when he was not present there? How can he say it is true to my knowledge?
Tax was paid up to 7th April.
Yes.
It is only fault only one head.
Whatever fault, that fault is enough
One head. Four
before
heads.
coming to court.
24th May 2022, you handed over these documents.
Yes, madam, kindly come to the chart.
24th May, it's not one day.
Madam, kindly come to the chart prepared by them. Fine chart. Paragraph 6, page 6, paragraph 9. On 4 heads. Number 1, fine penalty for without permit. Admittedly, I have the permit.
The tax section.
Only
If you have failed in your tax, the permit is rendered invalid.
next.
The law.
Next, madam, kindly come to the next. Paragraph number 2, fine penalty for carrying excess load. So far, to establish this fact that my vehicle was carrying excess load, on oath, the adding officer has stated in presence of driver, payment was taken. Where is the document? Where is the
Payment certificate.
certificate is the document. But
Vehicle
where is the-
number is there.
Where is the document to establish that my driver was present? He put his signature. in
Is
that
it his
document.
case, my lord, that I put some extra load on the vehicle and I, my lord, carry it to the women on the, and the, my lord, the vehicle number is there. So I put extra load on his vehicle.
From the day one, it is my case and
This
how,
story-
what manner I have been
Come
called.
with the
My
calculation.
lord,
My lord.
I'm afraid I don't think the rich court can help you. in this one.
my lord.
I don't think the rich court can help you in this one. Because you failed in your tax payment and all this.
Only one head I have fought.
That's
I'm
enough.
admitting that.
That's enough.
Even the
I'm
overloading-
admitting. Only on single head.
That's
Only
enough.
on single head.
Even the overloading.
Overload is their case. They have prepared the chart. My driver
Women
does not have
certificate.
any personal knowledge. How and what manner they know everything.
You have only evasively denied. You have not made out a specific case. It's only an evasive denial, isn't it?
I have stated in details. I have stated.
That is an evasive denial.
What more, my lord? What more I have?
How rich court can enter into all these things, lordship, kindly consider this
Let him
not
come
a
back.
suit
Let him
court.
come back. my lord.
Go further, it's a matter of evidence.
Let him come back.
And then, my lord, then all my lord, before the statutory appeal court,
Let him come back. with
which
the
has
evidence,
every
my lord.
power even to take, my lord, the, as a, my lord, the witness, my lord, deposition, everything.
Please come back with the,
My lord, in the next week, lordship,
no, after vacation. Next
after
week, not
vacation,
this.
my.
For learned counsels for the parents. Paragraph, learned counsel for the state respondents seeks to use a supplementary affidavit disclosing the it's a circular. It's a circular.
Circular.
The circular on the basis of which
Circular memo, mine,
penalty is assessed
mine.
by the motor vehicles department. Paragraph, let the matter appear under the same heading on 13 June.
13 June, Lordship.
Please serve an advance copy, Mr. Secretary.
My lord. Mine, obvious.
One 56.
You're not well?
Facing back pain.
Oh,
My lord, in the earlier date, my lord, I prepared this exception.
Stage 6.
The exception to the additional.
Next matter is also same point.
In the additional report, my lord, the transport department submitted a notification dated 1st March 2023.
if you want to sit and submit, you can do that.
Yes, no. The moot question in this matter is whether the vehicle submitted by the petitioner, two vehicles produced by the petitioners, pursuant to the offer letter issued by the authority sometimes in the year 2018, and the vehicle produced by the petitioners is the BS3 model, admittedly, my lord. But thereafter, no permit has been issued. On the other hand, sometimes on 20th October 2022, my application has been rejected. Though it has been granted in the earlier occasion, offer letter was issued, I have deposited the permit fees as well. 2022, the authority rejected my application on the ground that my vehicle are BS3 and they are not issuing any permit in respect of BS3, and I have to produce BS4 vehicle. Well, on the next meeting, my lord, they have allowed BS3 vehicles. On the same meeting, they have allowed BS3 vehicles.
Where is the document?
In my writ petition, my lord. And my lord, the basis of the rejection of my BS3 vehicle is, my lord, is an order passed by the Honorable Green Tribunal. In that order, Green Tribunal case, my lord, there is no such restrictions as the BS3. I have stated everything in my exception. Your lordship kindly come to the first. My exception is the second exception.
Yes.
Which has been submitted today, my lord. My lord, page 3, my lord, I have stated the offer letter was issued. I have submitted.
My lord, may I leave something? Mr. Naik is here.
My lord, page 81 of my writ petition is a rejection. Page 81 of my writ petition.
Yes.
80 is the agenda number 7. My lord, 81 is the region assigned and rejected my application. Muhammad Arif Hussain and Javed Ali formed absent on call. Learned advocate appeared on behalf of them.
their matter was discussed in details, and finally member of STA West Bengal decided to reject the prayer for replacement of vehicle as well as reject the application for grant of permit, which was allowed by STA in its meeting dated 17th March 2017 because permit with BS3 compliant vehicles is already restricted by STA resolution dated 27 November 2020, and also on the ground that he has failed to obtain permit since long. However, he has the liberty to apply afresh for the said interstate route or any other interstate route with BS4 or above compliant vehicles if vacancy arises. But this is the order dated, decision dated 29th January 2021. The next page, your lordship, kindly 27 November 2020. The basis of my rejection order is this 84, page 84. The third paragraph. The Honorable National Green Tribunal Principal Bench, New Delhi, in the matter of Way 33 2014, Subhash Dotto versus State of West Bengal and others, in the order dated 27 November 2018, observed that the principal reason for the ambient air was identified to be auto emission apart from the road dust and some other hazards. I have annexed this order in my first exception and submitted, and where from it would be cleared, my lord, crystal clear, that no such restriction has been imposed by the Honorable Tribunal in respect of the BS3 vehicles. Not a,
the tribunal doesn't approve any application for interstate route for.
no, your lordship, kindly have a look the order.
Please come to the penultimate paragraph of this.
Page 84, my lord.
Page 82 of your exception.
No, my lord. Yes, my lord.
Page 84 is the order.
84 is the input order.
Yes, the
exception, my lord. Exception, my lord. First exception. I have
first exception.
first exception.
Yes.
Page 16 starts, my lord.
16,
16. This is the order dated 27 November 2018, which has been added in the input decision, my lord. My lord, relevant portion, my lord, your lordship, kindly come to the relevant portion. Paragraph 4.
Yes.
Page 7. Page 17.
Yes.
The principal reason for the bad ambient air quality in the city of Kolkata and Howrah, in the city of Kolkata and Howrah, only for the Kolkata and Howrah, was identified to be auto emission apart from road dust, construction activities, burning of municipal waste and industrial waste, including plastic, population of diseases and industrial emissions. We had noted that the state had failed to take any effective measures to control the source of such emission. Specific direction had also been issued for phasing out vehicles which were more than 15 years old. That is the main criteria of the order, that all the 15 years old vehicles should be phased out. There is no restriction whether it is BS3 or BS4 or BS6. Now, your lordship, kindly come to the page. My lord, paragraph 12. Page 19 of paragraph 12. This is the operative portion of the order. We accordingly direct the state of West Bengal to pay a sum of ₹5 crore as interim environmental compensation, which shall be deposited with the Central Pollution Control Board. The amount shall be deposited within a period of 2 weeks from hence, failing which it shall entail further compensation of ₹1 crore per month of delay. This is being imposed following the polluter pays principle in terms of the section 20 of the National Green Tribunal. This is the operative portion. And this order has been taken into consideration while rejecting my application for BS3 vehicle. Thereafter, my lord, the Honorable Supreme Court's order. Page 21 starts. Here, my lord, only page 21 starts the Honorable Supreme Court's order. It has also been taken into consideration while rejecting my application.
Second exception or first?
First exception. My lord, this order only for registration and selling of vehicle, not for restrictions on the BS3. My lord, operative portion, my lord, your lordship, kindly page 24. Accordingly, page 24, last second paragraph. Accordingly, for details region that will follow, we direct that on and from 1st April 2017, such vehicles that are not BS4 compliant shall not be sold in India by any manufacturer or dealer. That is to say that such vehicles, whether two-wheeler, three-wheeler, four-wheeler, or commercial vehicles, will not be sold in India by any manufacturer or dealer on and from 1st April 2017. This is the crux of the order, that no vehicle should be sold or manufactured on and from 1st April 2017 unless it is compliant with BS4 norms. Paragraph B, my lord. All the vehicle registering authorities under the Motor Vehicles Act 1988 are prohibited from registering such vehicles on and from 1st April 2017 that do not meet BS4 emission standards, except on proof that such a vehicle has already been sold on or before 31st March 2017. I have purchased before 31st March 2017. But it has also been clarified by the Honorable Supreme Court, page 28, that so far sale and manufacture is concerned, page 28.
It's sale and registration.
Only sale or registration, not for issuance of permit. Now, my lord, your lordship, kindly, I am coming again, my lord. Page in my writ petition. My lord, 24th August 2021, page 85. This is the resolution of the authority after 7 months of my decision. My lord, page 86. Decision taken in the meeting.
Yes.
The matter was discussed in details and members of the estate decided that only those only approved applications for inter-regional route which are originating, traversing and or terminating with Kolkata municipal area by the STA prior to 27 November 2020 with BS3 vehicles will be allowed to get permit. Where application has already applied, where applicant has already applied with permit fees and other documents required to obtain permit on or before today, 24th August 2021. I deposited permit fees in the year 2018. I have been granted offer, I have been issued offer letter in 2018. So I come to the squad of this, their decision. Next, my lord. Page 87 is the decision on 29th January 2021. Page 89. First, second, third, fourth paragraph. Page 89.
Yes.
Mr. Mustaqam Ansari appeared personally. He produced documents for any vehicle bearing registration number WB37C4139, 2011 model.
This is BS4.
It is wrongly. I have objected it. That is BS3. In the year 2011, no BS4 has been manufactured. It has been concocted. It has been fraudulently taken, fraudulently obtained. Page 89. Court. In 2011, no BS4 vehicle has been manufactured and sold.
In the penultimate paragraph also
My lord, paragraph page 91 again, my lord.
of Mustaqim. Page 91.
91. Again, my lord, first, second, third paragraph. Mohammad Mustaqim Ansari already obtained permit. His vehicle as BS4 as per Bahon data. Specific objection has been made against this vehicle. Now, my lord, your lordship, kindly the last notification 1st March 2023, whereby before that so many notifications were issued from 2012 till 2019, which has been verified and tested by this honorable court as well as the honorable Supreme Court. That BS3 has been allowed till 2022. Now, my lord, your lordship, kindly have a look by the additional exception of the additional report.
Yes. Yes.
My lord, page 3, I have stated, my lord, second exception. My lord, this answering petition are in compliance with the offer letter dated 29th March 2017, issued and extended afterwards by the Deputy Secretary STO West Bengal for a further period up to 19th October 2018.
You are on page?
Page, my lord, 3 of my exception of the additional report.
Yes.
But that is filed today, my lord. In furtherance of the grant of permit was made on 17th March 2017. Submitted all the necessary requisite documents.
First paragraph.
Yes, my lord, page 3.
Page 3.
Paragraph 8.
With reference to the.
Paragraph 8. 8 ko nahi hai kare?
Paragraph 8 is in terms of the liberalized policy of the government. Not necessary. No, because the state will need another day. You will take some more.
Only, my lord, this. My lord, have your lordship got the exception of the additional report?
Yes, exception of the additional report.
My lord, page 3. That is the.
This is the additional report. Page 3, yes.
Page 3, my lord. At the top, my lord. In pursuant to the offer letter, my lord, bearing number at the top, bearing number dated 29th March 2017.
The page starts with the offer letter bearing number.
Yes, my lord.
Yes.
Issued and extended afterwards by the Deputy Secretary till 19th October 2018. Grant of permit 17th March 2017. My lord, everything has been done. Everything has been done. Now, my lord, your lordship, kindly. 9th October 2018 by docket number 3404. Annexure P3 to the petition. All the documents have been submitted. For issuance of the said permit, route, my lord, Kolkata to Kesar via Bardwan, Siuri, Dumka, Deoghar, Kolkata. So, my lord, in the agreement, route has been originated from Kolkata, but the permit is being issued by the authority from Satragachi, which is outside Kolkata.
but the permit was not issued with the extraneous reason best known to the respondent authority and the then Deputy Secretary ST West Bengal, Mr. Ali. Despite the initial vacancy of 10 permits has been fixed for the West Bengal under serial number 19 of the said agreement. I further submit that though the respondent authority seriously alleged that the petitioner could not produce the vehicles properly, but curiously enough, not a single document and or letter has been produced by the respondent authority in support to its bold and cryptic contention allegation. Well, in the impugned decision, they have referred the Honorable Supreme Court's order. I have shown that is stated in page 4, paragraph 9. Petitioner says submit that the Honorable Supreme Court in referred judgment dated 24th October 2018 was pleased to observe that therefore, in exercise of the power vested in this court under Article 142 of the Constitution, we read down sub-rule 21 of Rule 115 and direct that sub-rule 21 of Rule 115 shall be interpreted and understood to read that no motor vehicle conforming to the emission standard Bharat Stage 4 shall be sold or registered in the entire country with effect from 1/4/2020. As such, nowhere in the aforesaid judgment issuance of permit in respect of vehicle of the petitioner conforming to the emission standard Bharat Stage 3 duly produced before the respondent authority on 9, it has already submitted. My lord, next, my lord, green tribunal order, 27th of November. It has also been submitted before your lordship.
Yes.
But it is only for phasing out vehicles which are more than 15 years old and to introduce mechanism and instrument to check emission of moving overloaded heavy vehicles. Now, my lord, 1st March 2023. But your lordship, before that, my lord, your lordship kindly have a look at the impugned notification dated 1st March 2023, which I
incidental and very essential ingredients are there.
That cannot be implied. It has to be explicitly stated by the.
Only thing is this, since core issue is to curb the pollution, then Supreme Court is stopping all kinds of preparation. So does it mean that others?
Your authority is stopping. The Supreme Court is not stopping.
That's the
on the other hand allowed.
Learned friend.
The record doesn't say anything.
On the other hand, allowed, my lord.
The documents do not say anything. Please come back.
Now, the circular we have also the latest circular that is annexed also.
Very short.
Very short issue.
Very short issue.
Please come back. I'll leave you.
May I
and one thing has to be looked into whether Supreme Court has clarified or not. I will insert, certainly I will take instruction. My lord, you also will have to give some guideline as to what will be the restrictions, what will be the steps taken to curb the pollution.
That's required, Mr. Nayak. The Supreme Court and the NGT has very clearly stated that there is a restriction on
manufacturing and sell.
Yes. Nothing
stopped.
More. Nothing more.
And so thereafter we are trying
also
to
clarify that if it is done before the cutoff date, it will not be affected. So I do
That's
not
a major issue, lordship.
The authority has made this order.
Also flying also.
Yes.
No.
It also
Flying
flying.
No,
'Stop flying.
no.
15-year-old vehicle.
Stop flying of the vehicle.
Where is the
To
order?
phase out 15 years old vehicle.
I shall produce the Lordship kindly fix the any immediately after vacation. I shall-
that is
I shall
what
put.
my lord is-
I shall produce that judgment National Green Tribunal to stop flying the vehicle within such and such period. That is why state government went and.
Meanwhile, my lord, may I have temporary permit, my lord? Meanwhile, temporary arrangement to fly my vehicle.
Order against you.
Short date, lordship.
Immediately after vacation, I'll consider.
And your lordship kindly keep it
Thank you,
as
Your
part
Honor.
heart. Lordship kindly keep it as a part heart matter. Your lordship heard this matter
Cannot keep all matters.
6 or 7 times hard.
Exception used by the petitioner to the additional report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph heard learned counsel for the petitioner. Paragraph let the matter appear under the same hearing for further consideration. On 7 June, we are opening on 5th, 7 June.
Your lordship kindly keep it as part heart matter. If they
Seven.
7
হ্যাঁ 5 তারিখ খুলছে 7 তারিখ ঠিক আছে ভালো
next matter is the
Lordship.
same.
Next matter is also the same.
ফার্স্ট ম্যাটার আমি আছি
Same issue involved. Same issue.
সেকেন্ডেও আছে ফার্স্ট
Lordship. Lordship.
Next matter, same order.
Same issue involved.
Same day, same order.
157. 159.
Great, lordship.
For the writ petitioner in this matter, my lord. Lordship, this matter pertains to, my lord, the
Filing because. Yes.
yes, my lord, the petitioner, my lord, is a leaseholder with the Indian Railways. I have served the legal methodology also appeared on the previous occasion. My lord, on the basis of,
Some reports.
Yes, Malad. Report is ready, but not affirmative. Can you take it up?
well, only one
So that
aspect,
is-
my lord, they have wrong. Respondent number 5
Mr. Ansar Manoj is appeared.
He was here. They can, my lord,
Short pass, short pass.
the legal metrology, my lord,
ঠিক আছে
and the railways, my lord. They were both directed to file one report in the form of affidavit. Because of the reason, my lord, lordship's previous direction was quite clear. Lordship, kindly come to page 111. My lord, this is the second round of litigation. Lordship, kindly come page 111.
111.
111.
Yes.
I have annexed the order. This was the initial order passed. My lord, kindly. So I am reading, my lord. Instructions submitted on behalf of the railways authorities taken on record. Hard learned counsels appearing on behalf of the parties. It is contended on behalf of the petitioner. The petitioner is a registered leaseholder with the Indian Railways and is engaged in the business of transportation of goods through railways across the country. Petitioner being entitled to transport consignment within the limit of 23 tons. Learned counsel for the petitioner submits that while loading the consignment at Porbandar, the consignment was weighed and found to be within the tolerable limits. However, upon consignment reached Shalimar, it was reweighed and found to be overloaded by 8.13 tons. Punitive charge of rupees 4,99,000 was demanded from the petitioner, which was paid by the petitioner on protest. The petitioner submits that the consignment showed alleged overloading either due to increase in the weight of the empty parcel van which carried the consignment or due to defect in the in-motion weighing machine in which the consignment was weighed. The petitioner prays for direction upon authority to examine the in-motion weighing machine at Poddopukur Shalimar and reweigh the empty parcel van bearing such and such attached to the train number 12905, 12906 in terms of section 79 of the Indian Railways Act. It is contended on behalf of the Railway Authority that the in-motion weighing machine has been checked and verified by the Metrology Department and is found to be functioning properly. It is submitted by the learned counsel appearing on behalf of the fifth respondent that he has no instruction in this regard. Upon consideration of the submission made on behalf of the parties, the writ petition is disposed of, directing the fourth respondent to reweigh the empty parcel van as referred to earlier and check the in-motion weighing machine at Poddopukur. My lord, this is very important, my lord. And check the in-motion weighing machine at Poddopukur Shalimar in presence of the petitioner and the controller legal metrology being the fifth respondent herein for his authorized agent within 4 weeks from the date of communication of this order. Since the petitioner has already paid the punitive charges in protest, it is expected that in the event the weight of the empty parcel van is found to exceed the normal limit and or the in-motion weighing machine
is found to be defective, the punitive charges slapped on the petitioner to be refunded to him within 1 month from the date of direction thereof. The fourth respondent or any officer authorized by him shall communicate the place, time, date, and payment inspection directed earlier to the fifth respondent or his authorized representative, and the petitioner is at the earliest. With the above observation direction, this writ petition is disposed of, my lord. The direction was quite specific, my lord, in presence of me, the railway officials, and also in presence of the legal metrology, will take the empty parcel van through the in motion weigh bridge. I will check whether the empty parcel van is weighing correctly or not, and whether the in motion weigh bridge is functioning properly or not. My lord, pursuant to lordship's direction, 11th of January 2023, I was called for to attend the examination. Now, my lord, although lordship, I have paid the punitive charges, and lordship's direction was that not to take any further charges, the imposed haulage charges, that is 44,604, appearing as page 115. That I have also deposited, though there was no direction, my lord. Now, my lord, on that particular date, what happened? I went in the office from 10:30 AM to 6:30 PM. My lord, I was waiting for the repayment to take place, but on the basis of their assurance that it will not going to take place on that day, on a future day, I was asked to leave the office. I leave. Immediately after I left, my lord, they conducted the payment behind my back. My lord, I am not joining the issue, because lordship, kindly see from page 116, the report which has been filed by the railway authorities. Kindly see the weight on page 116 onwards. The empty weight weighs 34 tons. Now it is appearing as 31.60 on one occasion. Then next page, 31.80. Then on next page, 31.20. And next page, 32 tons. So, my lord, it can be demonstrated from here and now, my lord, the in motion weigh bridge was not functioning properly. So if that be the case, my lord, then I have annexed the honorable single bench judgment of a coordinate bench. Lordship has seen that on several occasions, and also the division bench judgment, Lordship, where it is categorically stated, if the in motion weigh bridge is defective, then adverse inference has to be drawn, and the punitive charges which have been wrongly imposed, that has to be refunded back. So, my lord, what I am up to is I have prayed for refund of the punitive demand, because on earlier occasion such demand, such prayer was made, and was on the basis of their report, my lord, it was refunded back to me. Now, my lord, the legal metrology department is required to say after this whether the in motion weighing machine is working properly or not, because from the railways report, it demonstrates it is not functioning.
The department intends to come back with a report. Mr. Mondal, do you have your report ready? You're not ready today? What about you?
Well, after 1 week after vacation, that will be better, because
Now,
next
now,
week
my
when
lord, I
vaccine
only
is coming,
beseech
my
one
lord,
thing, my lord. It is apparent,
subject to
and it's
lordship.
prima facie from the face of the record. It's not my document. It is a document which my learned friends cannot deny and dispute, because it is countersigned by the controller legal
Punitive charge, as far as punitive charge dispute concerned, my lord, that is subject to my lord, correction
No.
of the report, my lord. So I
report
believe,
is
my lord,
already here.
but
They
that is
have
separate, my lord,
It
separate.
cannot be a separate thing.
It's not separate, it's the same issue.
Their empty weighing machine is defective. Their in motion weighing machine is defective.
Without, my lord,
Come back with the report.
Only one prayer, my lord, the 5,50,000 rupees which I have paid, which is lying with them, I will say illegally, my lord, at present, because of this, that should be lordships deposited before the registrar general, my lord. This amount, no, they should not enrich themselves illegally.
public money, my lord.
The public money you have wrongly imposed. Already, kindly see the division bench order.
Come back with the report, it will be disposed of once and for all. Please come back on the next day with the report. Learned counsels for the respondent seek extension of time to submit the reports in the form of affidavit as intended. Paragraph is going to appear on the same meeting on 13 June.
Only I will make one prayer. I will not, they will not object. It will be parted, my lord. There's a possibility of change in determination, my lord, after October.
I'm sorry, sir, I will not carry the entire this determination to my next determination.
It had me hard, my lord, on several occasions.
There are lots of matters which are heard on several occasions. This is not
Instead of 13, my lord, 14, my lord. Instead of 13,
Instead of
unlike
13,
13.
14.
Except
The 13th is lucky for me, my lord.
14, my lord,
Let-
it's not difficult. 14.
Very well.
14. Deep level.
The luck depends on the brief and not the date.
My particulars are there, but I have a cast iron case this time.
14, Bashu.
160.
Well, I want to file an affidavit to exception taking into report, my lord.
Mr. Naik is appearing.
My lord, my lord, my lord.
Have you received a copy
Well,
now?
it was hard violation the other day.
No advance copy was sir?
No.
Lord, I believe, Lordship, I do not know what exception or
The report has been filed by the police department.
Yes,
I
yes.
took exception.
It
It is the motor vehicles department who has to come forward.
My
For
lord,
that reason, I have to
Yes, sir,
file
that's all.
the exception.
I most respectfully, my lord, and humbly submit my lordship once that on that particular routes, my lord, different other, my lord, vehicles or autos are being plied on, having no, my lord, permit and all this. So that should be taken care of. Now, my lord,
Fake registration, fake grant of permit, everything illegal.
I don't dispute.
No, I
So we made inquiry through our machinery. One of the wing is our police, because motor vehicles officer will not go and stand and will catch hold of any.
But who will submit the report,
Yes.
Mr.
We
Naik?
submit report.
DM is to submit.
The report.
District magistrate is to submit report.
No. We have
Because
submitted
he is
report.
chairman of the RTA.
My lord, we submitted a report, my lord, on the last occasion.
Where is your report?
Officer, against that, my lord, he is filing the. This is our report. Lots of kindly says.
Police officer.
No,
The report is by the police
that is
officer,
there.
not
We
by
have
the
filed the report.
police report.
My lord, we have submitted report. My lord, the report is there. I have given a report.
How the police come?
My lord,
By the police, not
Yes.
by you.
yes.
The
Not
authority should come back with a report.
very well, lord. So we shall rely on this very well. Because we are to, my lord, take action through
Police
police.
may render assistance to you.
Yes, madam.
But you should come back with the
That's
report.
a technical thing. We shall cover it up.
Not technical, sir. It's more than that.
But obviously, my lord, we shall do it. We take responsibility. But at the same time, also kindly appreciate.
Let the report in the form of affidavit be on record. So that it
Thoughts.
can be acted upon.
And one thing is very clear, my lord, we
So will you take this back or not?
we take assistance of, my lord, our hands, and we through them we get it.
Of course, you can take assistance, but the report will not be submitted.
Very
by
well.
your-
That's, my lord, I say, my lord, in my humble
Your
understanding.
assistant has submitted the report, not you.
Well,
So it should be the
he is
authorities.
technically right, I am saying, but
For
technically,
that reason, I have filed my.
while Unetwin is technically very sound, he wants, my lord,
Learned
proper
counsel
person.
for the respondents
Grateful.
seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same, please serve an advance copy, Mr. Naik. Let the matter appear under the same heading on 13th June.
Grateful.
161.
My lord, I beg to appear for the petitioner, my lord. May I hand
Lord,
over the affidavit of service?
161.
I am appearing for the respondent number 8 bank
Respondent number
8.
8. What were the
Property.
others?
My lord, the transport authority is there. The state has been submitted through the government pleader. And my lord,
Respondent number 9, the private respondent.
private respondent has been served, my lord. That is the last page, page number 8 of the affidavit of service. It would-
No one is appearing for the authority, the transport department. May I request Mr. Devra to appear? Regularize করে দেবেন তো ওনারাই পরে affidavit of service. None appears for the state respondents despite service. Mr. Devra. Please give him, please hand over a copy to.
I shall, my lord.
Along with my junior. Yes, along with a junior, with a learned junior of his choice.
আমি respondent আমি ভুলে যাচ্ছি।
Yes, please serve a copy to him.
My lord, I shall, my lord. I do not have it right now.
Short matter which he can deal with here and now.
Perhaps, my lord, because it is already admitted, the petitioner had bought a vehicle, my lord, a 14-wheeler by way of taking a loan from the bank, my lord, the respondent bank. It was hypothecated. Thereafter, if my lord kindly comes to page numbers 28 and 29. The loan has been liquidated. They have sought for the endorsement of hypothecation made on the registration certificate to be dispensed with. And my lord, so that the petitioner can, my lord, take steps with regard to the vehicle, which he cannot do. That is the, my lord, main grievance. At page 36, my lord sees that has been blacklisted. And the reason for blacklisting, as has been provided, page 36, my lord, is the it's a screenshot from the website.
Yes. What's the ground for blacklisting?
Yes, it states that it has been blacklisted as per Nando Kumar PS case number 420, 400, and 420, 406. So, my lord, if I may submit, my lord, what had actually happened. The petitioner had taken bought the vehicle on loan. He had an agreement with another person, with the private respondent. He was supposed to pay the loan amounts. I mean, he defaulted. The vehicle was seized. Thereafter, the petitioner himself paid back the loan amounts, everything. And thereafter, my lord, this page number 28 and 29 have been issued by the bank saying that the loan has been liquidated. And thereafter, this FIR has been made by the private respondent, making, my lord, somehow the issue of the vehicle as a crux, my lord. And that I have annexed, my lord. It is there, the complaint. But perhaps on that ground, it can't be blacklisted anyhow. And without giving me an opportunity of hearing, my lord, this has been done.
The private respondent claims to be the registered owner of the vehicle.
No. My lord, no, my lord. The registered, he
Granted these to the private respondent, agreement.
there wasn't, that agreement is there. My lord sees that agreement is at page 48.
There is a police report, my lord, filed in terms of the order passed by the investigator magistrate.
No, CGM.
No, CGM.
Yes.
Chief Judicial Magistrate Tomlu.
Yes.
Therefore, it appears that there is a criminal case, my lord. They advanced for a 5 lakhs rupees.
No, my lord, that is perhaps in my favor, because if my lord kindly comes to the order before the criminal court, there, my lord, the police has said that this has not been seized with regard, the vehicle has not been seized with regard to this case.
No, police has not been seized.
I do not seize the vehicle such and such. My lord sees the last line.
Lordship, may I submit one thing, my lord? Lordship,
Yes.
turn to
I have one.
page 60, follow like minute. Page 65, Lordship, kindly see. Let them, my lord, let that thing be considered by the RTA, Secretary RTA.
My lord, we had made that is my representation, my lord. That has not been considered. That is why the writ petition.
Only I am subject to correction. I respect his usual fairness. Not only whether the act empowers him, my lord, to, my lord, pass this order, my lord, blacklisting the candidate, the petitioner. In a private dispute, my lord, this point, my lord, is required to be considered by him while, my lord, taking. Otherwise, my lord,
That has to
and
be looked into by the authority.
yeah, no, I am not saying. I said, my lord, and my lord, they said, page 47, because today is fixed for returning the seized vehicle, number such and such, seen report, stating that vehicle number such and such has not been seized by this case. IO is directed to submit a fresh report regarding the seized vehicle number such and such. Suppose, my lord, there is a dispute between the lessor and lessees pertaining to the vehicle. My lord, your lordship has taught us, my lord, that in a criminal jurisprudence, everyone is presumed to be innocent unless proved to be guilty. So, my lord, even if there is an FIR with regard to the breach of contract, non-fulfillment of contract, which gives rise to 420, even then, my lord, whether it has, my lord, any business or bearing, so far as the blacklisting of a person, my lord, who, my lord, seeks transfer of name, and when I particularly, my lord, may paid off my debt to the cooperative bank. So, my lord, whether this is an action, my lord, supported by law, and if your lordship does not want to interfere and direct the matter to be discussed, decided by him, kindly, my lord, frame the issues, my lord, so that the gentleman can have. Otherwise, my lord, the man can be directionless, because he has passed this order without looking into the law. Kindly set aside the order and kindly frame the issues.
Cannot be done at this stage because the criminal case is pending. let the authority decide. This court will not go into merits at the moment. Let the representation be considered.
Considered, but whether the question is whether
Because
the
if the transfer is made during pendency of the criminal case, that will not be prudent.
no, I subject to correction, my lord. First of all, an authority exercises power under the law. Now, my lord, question is whether the law, Transfer Motor Vehicles Act, my lord, whether it empowers the authority that while blacklisting, he has to consider certain parameters. Whether filing of an FIR or the pendency of the criminal case, when it is a dispute between some person and with regard to the violation, whether it is a blacklisting.
Let the RTA says.
Yes, but the question is, I have made this submission.
Practice has to be called for from the authority.
Then we will kindly ask him to file a report before your lordship.
To explain the situation.
Explain the situation.
But a petitioner copy.
Copy দেয়নি?
আমি তো সার্ভিস হয়েছে
Service
কিন্তু
হয়েছে বলছে।
স্যারের কাছে স্যারকে অ্যাপয়েন্ট করেছে কোর্ট
Not appears on this paper, you know, paragraph.
কালকে কেন করেছিস?
কালকে হয়েছে? আসার কথা রেট। এসছে।
The order passed by the
Before your lordship passes this order, when I served the notice to the GP, I said the matter will come up on 15th and it was served yesterday.
Since no one is representing the state, I requested Mr. Devra.
So, no, I must tell the truth that because I intimated the office that it will be taken up on 15th.
On 15th.
Yes, but this must be disclosed to your lordship.
So will you come back on 15th in that case?
বললো, তো তো বলছি।
আরে তাই দাও দেখো।
12/5.
ও 12 তাতে ফিরে এসেছে।
15th is here, but
The
12th,
presentation form says 12th,
12th. Oh.
but the notice.
But the notice said,
15th.
but in Sharthak Miller, in my copy it is 12th, but in their copy it is 15th. And without my initial,
In the bank's copy,
no, a private respondent.
he's the bank.
Yes, bank.
Private respondent is not appearing.
Yes.
ওখানে একটা line করবেন, none appears
আমার
to
initial.
private respondents despite service. The state respondents and the private respondent despite
বলে দিলাম ভাই
service.
যেটা বলে সেটা বললে আমি আপনাকে
So I think it will be better if we can keep it on 15th.
15th is not the date for taking up this matter.
I'll fix it on 15th to the 15th is Monday. So if I make it not today, it will automatically appear on 15th.
Am I required to serve another notice to everyone? Otherwise it will not reach me. Today is Friday in the afternoon.
I have actually appointed, I have regularized the appointment of Mr. Devra. So let him be present on that date.
No, your lordship, since all are present, no, not all are present. Oh, then we'll have 15th.
I have requested Mr. Devra to appear. There is no one representing the state. So it may so happen that
There has been someone
on
appointed.
that.
Then we'll have kindly regularize his appointment.
I have regularized his appointment,
Yes.
but I want to wait till the 15th. Because it may so happen that the.
So I must indicate, otherwise it will be misleading.
Absolutely. So to avoid.
As you lordship, yes, it's convocation 15th.
Mr. Devra, let it appear on 15th.
May I take my lords kindly?
Heard learned counsels for the parties, let the matter appear under the same heading for further consideration on 15th. May.
Seven motions from monthly list, item 959.
I'm for the petitioner. This writ petition has been disposed of by an order passed by the appeal court.
By the appellate court.
Appeal court. An appeal was preferred from this order of 11th December 2017. But it-
Take your. File not required. File not required. Order.
11th December 2017. Kindly come to the last page of the order. Third page.
monthly first একটা কল হয়েছে দেখো 900 স্যার হ্যাঁ কি করব
Yes. The writ petition has been disposed of by an order passed by an honorable division bench of this court on 11th December 2017 in CAN 11121 of 2017 in MAT 2087 of 2017.
But the copy of the order be kept.
Copy of the order of the honorable division bench is taken on record.
Nine 61.
Uh,
961.
My lord, I am in one.
Yes.
My lord, I am appearing for petitioner, my lord, praying for a date after vacation, my lord.
On prayer of the petitioner, the matter is adjourned. Let the matter appear on the same heading on 20th June. 28th 20.
962.
But I am for the petition. But the application has been made, my writ petition has been filed against the non-acceptance of my application along with fees. But during yes,
I appear. my lord.
during pendency of this writ petition, they have accepted my application along with fees, my lord.
So nothing further remains.
My lord, kindly direct them to consider the said
After
application.
recording this, consider
The
in
only-
accordance with law along
yes.
with those who are in the fray. Because this is, my lord, the I think notified route.
Yes.
So number of applicants are much more than the vacancy. So along with other, my lord, the applicants.
The petitioner applied for stage carriage permit before the concerned authority. Affidavit of service.
But they, my lord, may I tell only. But they made an attempt to make their application through portal. But since, my lord, it was not accessible, that is why they filed a writ. Now it says, no,
They
they
have
already access to that and accepted that.
Accepted application along with fees. But in terms of annexed P1,
Along with prescribed fees, which, according to the petitioner, was not accepted by the authority. Stop. Learned counsel for the petitioner submits that during pendency of the writ petition, the application has been accepted by the authority and is pending consideration.
application along with fees.
Fees have stated.
Yes.
The
Application along with fees.
Stop. The petitioner has also deposited prescribed fees along with the application. The petitioner prays for a direction upon the authority to consider the application at the earliest. Paragraph, it is submitted on behalf of the respondents that
Respondent number 2.
the second respondent be directed to consider the application in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the.
Because this direction be given because there are other applicants.
I
also.
will.
Yes.
The petition is disposed of, directing the second respondent to consider and dispose of the application submitted by the petitioner within 6 weeks.
My lord, I do not know, my lord, how many applicants they are also waiting for.
2
because
months.
Within a period of
6
2
weeks,
months.
6
No,
weeks
no,
enough. Next board meeting করে দিচ্ছে আজকে।
Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the.
কতদিনের মধ্যে করবে?
সেটা বলেন।
মানে application
To-
যখন invite
না,
করছে,
না,
বলেন।
বলেন।
to all the interested persons, including the petitioner and other applicants for the route in question, in accordance with law.
And they will communicate the decision.
The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
Next matter, same.
Next.
66.
63 there. Next
Same.
time.
963.
Affidavit of sale.
Same to.
Same.
Application accept করে নিয়েছে। The puppy. ওটা দিয়েছে।
964.
Yes, same, my lord.
Same.
My lord, I pay my lord.
Application has been accepted.
Same.
Same. Same order. These are all accepted during pendency of.
Yes. Independent.
965.
965 malai appear.
My lord, only one thing, lordship, in support of that, my lord, one report has also come. May I hand it over to your lordship in 964?
Is it necessary? Is it necessary?
দিয়ে দিয়েছো তো? Lordship.
965.
965 lordship I
Same.
appear.
Same order.
নিয়ে নিয়েছো তো accept করে নিয়েছো?
966.
My lord, in this matter, my lord, they did not accept my application.
Same order.
You did not accept.
Did not accept.
How
Due
same
to
order?
offline, my lord, it was, my lord, due to
So accept and consider.
Yes.
Yes.
এটা offline.
offline.
Online.
Order has been passed for receiving offline. And thereafter, my lord, in another board meeting, my lord, it will be decided in respect of
received
other.
it?
Yes.
No, my lord. Till date,
That
my
is
lord,
my instruction,
I
my
could not, my lord, they did not receive.
Not received.
My lord, order has been
Fine.
passed to the effect that it will be received on offline.
But it has not been received as yet.
Yes.
But it will be
So
received.
received
ma'am.
and considered.
Yes. My lord, that.
The petitioner complains that the application for issue that the application for issuance of for grant of stage carriage permit in his favor
My lord, may I hand over one such order, my lord, for non-acceptance?
same order in his favor has not been accepted by the authority, far less considered. Stop. The petitioner has also deposited prescribed fees along with.
No.
Oh, you could
Not yet. Application along with fees to be deposited, man.
It is paragraph. It is submitted on behalf of the respondents.
Technical problem এর জন্য দিতে হবে।
Second respondent is.
Yes,
the authority.
second respondent.
That the second respondent be directed to consider the application.
My lord, they did not, till yet, they did not accept.
And consider the application.
Respondent secretary, I think, is a party, right? Yes. Madam, that respondent be directed to accept his application and the application will be considered by the respondent number 2, that is a RTA board.
Respondent number 3 will accept.
Secretary will accept. That three.
That the third respondent be directed to accept the application and application which shall be
Application along with
considered-
fees, my.
accept the application along with prescribed fees,
আছে অনেক কিছু আছে।
which shall be considered by the second respondent in accordance with law. Paragraph in view of the above, the writ petition is disposed of, directing the third respondent to accept the application made by the petitioner
Along with fees,
along
my.
with prescribed fees for the same. Within 1 week, acceptance within 1 week. Within 1 week from date, stop. The said respondent shall make over the application to the second respondent.
Third respondent, my lord, secretary, third respondent.
Accept
Third will
second
make
respondent.
over to the second
Yes.
respondent who shall consider and dispose of the same within 6 weeks.
6 weeks.
6 weeks. Within 6 weeks from the date of receipt thereof, On
About 2 months.
affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the other applicants for the route in question, comma, if any, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
Within a period of 7 days. Communication.
7 days, 1 week.
Affidavit of service.
Affidavit of service.
967.
I'm for the state.
Right?
Similar, 67.
7 to হয়ে গেল এটা।
না 66 হলো।
66 first.
Item 966 they have received, but item 967 they did not receive.
That is I am saying.
Oh, that was exactly, it 967.
Yes, I am extremely sorry.
Same. So 966 will be the same.
Same.
67 হবে, 967 to not received.
Great.
This was.
It 968.
It's the center of it.
No, your lordship, it is regarding. Sorry, it is regarding registration of e-vehicle, your lordship. A can has been filed by him, but it has not been served. Let the can be allowed and the usual order be
Served.
passed. No, it has not been served. Serve the copy.
Please serve in now it's.
Let the can be allowed and usual order be passed, your lordship.
Lordship, I'm praying for not to on behalf of the petitioner.
On behalf of the petitioner.
Petitioner, I am for the petition 968. Manish. কোথায় নাই? হ্যাঁ, monthly list.
968 দেখুন। State.
968
Have you served?
968 তো দিয়ে এটা কার লিস্ট দেখছেন আপনি?
Monthly.
968 to Manish EB. হ্যাঁ, Manish তো। Manish Kumar. It is not your matter. 968 is our matter. Which court you are looking
10
at?
number.
নাম্বারটা বললেই তো হয়ে যাবে। 968 দেখুন। Manish EB International Private Limited.
Where is your affidavit of service?
Yes.
Sorry, because the state is not appearing.
968. State
Your
is
affidavit, Mr. Sen, you are appearing?
service is also there.
Where is your order?
The same order, Mr. Sen.
Yes. Only thing, lordship, by instead of এখানে addition of party আছে।
হ্যাঁ, উনি করে
Can one order was by consent of the parties, by consent of the
Petitioner.
petitioner.
Affidavit can one করুন।
সার্ভিস করে দেন।
আচ্ছা তো order গুলো আপনার কাছে। কি হচ্ছে? Can one to allow by consent of the petitioner that petition is allowed. দুটো নয়।
একটা অর্ডার শিট দেবেন। হ্যাঁ, আপনার ইয়েতে সরি লর্ডশিপ।
না ওনাকে
পেজ 167 এ আছে।
সবসময় হাতে একটা অর্ডার থাকলে
একটা প্রিন্ট আউট রাখলে সুবিধা হয়।
Can one of 2023 by consent of the petitioner. The party is. আর on prayer টা হবে না, না on prayer of the petitioner টা হবে না, already আছে। Third learned consent is এই পার্টটা। The director is already treated as a party here. Director transport director, third base
167
third learned
170
consent. This is not the order. Where is the order? The division bench order has to be recorded.
For division bench, I am not having a lot.
Division bench order আছে last যেটা করেছেন কত last দিন আপনারা দিয়েছি কি না
My lord, day before yesterday.
Give the printout of the order. I mean, office থেকে
there
মানিয়ে
is an observation of the division bench with regard to order 1 rule 10 filed before the trial
And
court.
subsequently.
Yes, so that has to be recorded.
My lord, I will hand over the order copy in 10-15 minutes.
Only thing, Lordship, I am concerned that finally the direction should be given upon the concerned registering authority. Because initially, my lord
That
was,
was done in the, yes,
Yes,
that was
yes.
done in the,
Yes.
this is an earlier order.
that was the earlier order, the director to issue the order, no matter now. The
Third
order
is-
modified.
Additional.
এটা তো স্যার আজকে থেকে order ছিল, কারিগরি।
হয়ে গেছে।
ওটা একটা copy দিয়ে দিন।
এই মামলা হবে, এইটা হবে। আর এখানে 7th রেসপন্ডেন্ট আছে, 3rd রেসপন্ডেন্ট। অর্ডারটা আমাকে একবার দেখতে দেবেন। ওই ডিভিশন বেঞ্চের অর্ডার। আপনি করেছেন।
Lordship, I am handing over the order.
Observation. Yes, next, this was.
I'm great.
This was.
Great.
969.
969,
I am appearing.
petitioner,
Mr. Samant to Mr. Dilkar, depend on the other petition. After the vacation, I take some instruction.
no one for the petitioner.
Mr. Samant is appearing. Yes, Mr.
Samant is appearing.
Yes, Mr. Dilkar Samant. Just.
You want to take instructions? None appears for the petitioner. The learned counsel for the state respondents, none appears for the petitioner. Learned counsel for the paragraph. Learned counsel for the state respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 20th June 20.
970.
Petitioner, petitioner is not there at all. Victim, I'll release the matter. Let me release the matter. Lack of determination.
Because if I want for the after then again.
So let the petitioner come. Let the petitioner come. None appears for the petitioner. Let the matter appear under the heading. Under the heading 7 motion. Under the same heading on 21st June.
Yes. 71, 971.
971.
I beg to differ. In this matter, I am appearing on behalf of the petitioner and filing affidavit service.
Who is appearing for the respondent?
971. Here indeed is a very short matter. Because I applied for luxury, my lord, taxi park.
Yes.
All of that, the offer letter was issued, page number 10, long back.
Well, I have preliminary objection this matter.
To the maintainability?
Maintainability, but maintainability, I'm not on that. But whether the court should entertain the writ petition after, my lord, the
But to application for luxury taxi on 24th of September 2014. And after that, my lord, one representation on 29th of November 2022. Let him make a fresh application. 2014 application. And after that, my lord, 2022, one representation and then writ petition. My lord, Supreme Court said these are all stale claim.
Mr.
These should not be entertained. There are several judgments.
Dot of water has flown
What
through
Yes.
the branches after.
I am the petitioner.
They pele kotheke
I
egulo?
have placed my matter at first. This is the police.
He's raising.
This is the only point.
On the ground of delay.
I've already deposited the permit fees also.
Whatever it may be.
And I visited several times. The last in a few days back, my lord, the deputy
How do
secretary
you
asked
explain,
me,
how do you explain the delay?
delay means
From
I
2014
went
to
to several times.
2022.
I went to several times. I visited the requested because I've already deposited the
Have you
permit fees.
stated that in your,
Well, kindly see the document. Yes.
have you stated that?
Yes, sir, I stated so. Can you see the page number at first, my lord? Page number 10. This is the, my lord, offer letter. Authority decided to issue the state my luxury taxi permit for the middle portion. You shall purchase the new right at the desired store. That was issued on 24th September 2014. And time limit was fixed, one of cut-off date was fixed. Within the cut-off date, I deposited, can you see the page number 11? Page number 11. And I informed the secretary, State Transport Authority, that I have already deposited the permit fees because ST has no counter, it has deposited in the office of the Reserve Bank of India. Or the page number 12. 10,000 dollars. Why you are giving comment? It's a bad habit. This type of practice
Sir
will
Khan,
duplicate it. It's
the
not
copies are not legible. Copies
maintain
are
the
not legible at all.
No, I'm saying.
Copies are not legible at all.
Page number 12.
Page 11, page 10 is not at all
Page
legible.
11, my lord. These are representation. Along with my lord, requisite permit fees. 10,000 I've deposited. Page number 12. Page number 12. 10,000 deposited. 124 within the reasonable period. Then I also, along with I have submitted the my lord, the RC, this is the my lord, registration certificate also. Registration certificate of the vehicle. And also my lord,
This is in
other
2014.
page number 13 and 14. And 15 money insurance certificate, everything was done.
When was it done? In
Yeah,
2014?
Yes, within the reasonable period.
So after 2014, what
Why
steps
I
did you
my lord?
take?
Because I went several times, because I find I deposited 10,000. So I this is my duty to go here. Then my lord, I made the representation page number 70. On 30 November 2022. And I have stated elaborately and requested my lord to grant the permit. I made the representation. Then my lord, I have been asked that actually you have deposited the 10,000 in the Reserve Bank or not. Then I went to the Reserve Bank and I got the certificate. That was placed, kindly see. That issue was by the Reserve Bank. That yes, rupees 10,000 the admitted fact I have deposited. So let them direct to take decision. Reserve Bank ko bole diyese 10,000 jama diyese. So let them direct to consider my representation. Eta kotheke janbo? Horat point take kawaj bar. 10,000. আরে কোন জমাটা দিয়েছি আমরা আমাকে জানতে চেয়েছো রিজার্ভ ব্যাংক বলেছে হ্যাঁ 10,000 ওই ডেটে জমা দিয়েছে which can you directly consider my representation, nothing else.
The difficulties in my lord,
Difficulty because I have also served 24 years I have served at the transport department.
Let him make his submission.
This type of my lord submit in this way, sir.
Let him make his submission, Mr. Khan. Yes.
No litigants are here, there objection.
We know that it is very
Adequate
hot
person,
outside, so I
person,
think
my
we
lord.
keep our cool, isn't it?
I admit, man. Well, so far on sympathetical ground, because a persons will be ruined. Because he purchased the vehicle, yes. Yes,
Mr. Khan.
I cannot stop him unless he
Mr. Khan,
innocent person,
Mr.
then I
Khan.
advised him. It is a delay.
Mr.
I'm advising
Khan.
the bag.
Temperature is very high outside,
Yes,
we
I
all
know, right?
know. So this will not raise the temperature in the courtroom also. Yes, sir.
My lord,
Presentation, I advised him for my.
Please.
my lord,
Yes.
suppose these are all admitted fact. Suppose I admit everything that in 2014 pursuant to offer letter, this amount deposited, suppose for the sake of my lord argument, I accept it. Now in 2014 matter, she kindly consider, we are in 2023, bearing one representation in the middle 2022, in the midst of this entire period. Now, my lord, kindly consider a person who is interested in the matter, whether he kept silence for over such a long period, from 14 to my lord 2023, that to knock the door of the court after my lord 7 years.
An
10 years.
explanation has been given in the report.
My lord, explanation. Now I leave it to your lordship because I all honor. My lord, may I tell one thing? Later, I just, my lord, the copy of this, nothing would be traceable now. I am sure. Because, my lord, this is, my lord, the man.
Copy of all the
Nothing would be traceable. Another thing is, my lord, whether this 10,000 he deposited on this account not, my lord, this is, my lord, not, let's say, kindly not legible. Now he says that another, my lord, the certificate of credit just handed over it. Now, all these things then has to be considered by the authority concerned. First of all, fresh application, let's say, kindly consider, or, my lord, a copy of the same. And if he has deposited this, then, my lord, this document is to be considered by them also, that whether this is in respect of that, my lord, the application,
Consider everything.
including this.
Yes.
Including this, what he claims that the payment already made,
Yes, yes.
including this, is to be considered upon, my lord, production of document. Very good, lord. Oof, and I can't.
The petitioner contends that he applied for issuance of an all Bengal luxury permit in respect of the vehicle in question before the respondents.
And, my lord, the allegations contained, my lord, made therein are all denied.
Yes,
Yes,
that
sir.
will be recorded,
লিখেছো তো অনেক।
which was placed before the STA board meeting on 17th June 2014. Stop. Pursuant to resolution taken in the meeting, comma. Offer letter was issued in favor of the petitioner. Today memo dated 25th June 2014. 25th June 2014. The petitioner deposited the requisite fees before the
তুমি মামলা করছো না
Reserve Bank of India
বন্দে ভারত চালাচ্ছ আমি বুঝতে পারছি না।
on 24th September 2014. Stop. Despite several attempts made by the petitioner for issuance of permit in his favor by the authority, comma, the authority remained silent over the matter, for which the petitioner submitted a representation in this regard before the authority.
But these submissions are denied.
29th November 2022. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the in denying the allegations made by the petitioner, comma, learned counsel for the state respondents submits that since there has been inordinate delay in pursuing the application by the petitioner, comma, the petitioner ought to make a fresh application before the authority accompanied by relevant documents.
And petitioner did not turn up in the meantime, Lordship, kindly, my lord. It is our contention.
Then it
To,
further
no, no, no,
submits
তুমি বলেছো, আমি বলতে পারি।
that the petitioner failed to approach the authority during the entire period
My lord,
of
my lord.
pendency of the application
My lord.
without any cogent reason. Paragraph. It is a fact that offer letter was issued in favor of the petitioner with a memo dated 25th June 2014
কোথায়? আমি তো কিছু পড়তে পারছি না।
and representation was submitted by the petitioner only on 29th November 2022. Stop. In explaining the said delay, the petitioner submits that he approached the authority on several occasions for issuance of permit, but his request fell on deaf ears.
But no offer letter is annexed to my petition group.
Yes.
Number 10. Page number 10. Well, nothing is legible, Lordship. And in any event, my lord, only one thing, Lord. In any event, my lord, that offer letter is no more valid right now.
No, that time I deposited within the valid time. I complied all all terms and conditions of the offer letter.
On his part, there was no license.
No latches.
Let the authority
No latches.
consider.
Only
Let
delay
the
concern they will
authority
examine.
consider.
Yes. Let them
Uh,
consider.
Otherwise, my lord,
That as it may,
only thing, my lord, I would not want to disturb your lordship, my lord. Only thing, my lord, suppose, my lord, if the after offer letter, my lord, before putting the permit fees, my lord, one has to produce the vehicle and all the papers. Lordship, kindly consider this thing, because this is the, my lord, the condition of offer letter.
Has the authority played its part? After the amount was deposited, what was the authority?
But the
done? What
amount
steps have been taken?
May I tell Lordship one thing? May I tell? Amount has not been deposited with the permit issuing authority. The whole thing is this, what they are doing, the person whom my lord seeks the permit, amount deposited with the RBI. I think though it is not possible, my lord, it is not legible, but I am sure that the
It has been informed to the authority, page 11.
Within the time, within the time, I mean deposit.
Page 11, it has been informed. to the
আমারটা
authority.
পড়া যাচ্ছে না, আমি কি করবো? Nothing is legible.
এই কপিটাই দিয়ে দিচ্ছ। তার সঙ্গে যে 10,000 টাকা জমা দিয়েছে এবারে উইদিন দ্য টাইম আমি সব কমপ্লিট করে দিয়েছি।
তুমি কেন মিথ্যে বলো?
No reason has been assigned by the authority as to why the application of the petitioner was not as to why permit was not issued in favor of the petitioner despite the petitioner complying with all formalities within the stipulated period of time. Paragraph. Be that as it may, comma, since the representation submitted by the petitioner before the authority is pending consideration, comma, the concerned authority being the second respondent
My lord, I think
সেক্রেটারি সাফিসিয়েন্ট।
or the second.
no, secretary na.
So the second,
Permit, STA, respondent number 2.
the second
Yes, yes, I have.
respondent, concerned authority being the second respondent is directed to consider and dispose of the representation within 6 weeks.
Yes.
From the date of communication of this order.
In accordance with the present.
Upon considering the, upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law.
Right.
Stop. Since the matter is pending for long, the petitioner shall produce a copy of the representation, application, and all other relevant documents.
Which
before-
he is relied upon,
all other relevant documents relied upon by the petitioner
my lord,
before the authority at the time of hearing.
grateful,
বুঝলা বুঝছো?
my lord.
আর ডাকার দরকার নেই। আর ডাকতে হবে না। 4:30 মিটিং আছে।
এ কি সব খুলে গেছে কেন? এই না, এই আপনার বলে দিতে হবে। আমি কি করব? তুমি ওইখানে সব দেবে তো আবার, আমি আর কি করবো? দিদিস না, get